Please, your Lordship. Lordship, beg to mention item 24, Lordship. Lordship, pray for some accommodation today, Lordship.
Why?
My Lord, just for a day. My Lord, the senior leading counsel is out of station, my Lord. Just for a day, my Lord.
This is for filing of amended cost title. Wait, let the matter be called out.
Oh, my Lord.
Why have you not filed the amended cost title? Let the matter be called out. Orders cases need not be adjourned. Let they be taken up.
My Lord.
Yeah, please.
Yes.
So I beg to mention item number 25, my lord. I've taken the consent of the other side, my lord. Let's
Ah.
regarding my PIL where my lord, the Aadhaar, my lord, left, my lord, other cards from NRC left also being sought, my lord.
SLP is pending.
Yes, my lord, pending, my lord.
The SLP pending before Honorable Supreme Court regarding analogous issues has still not been decided. This yes, start coming. This court is informed that SLP pending. Thus, the matter is adjourned by 8 weeks, awaiting outcome of the SLP.
26.
Pending, matter pending. 26 also.
May I please, your lordship? Lordship, I beg to mention item number 33, lordship, with the concern of the other side. Lordship, I am appearing on behalf of Mr. A. Galda, lordship. So we need to file some affidavit in reply, lordship.
Then counsel for the appellant has circulated, petitioner has circulated an adjournment slip. He further submit that he is desirous of filing affidavit in reply, and 4 weeks time may be granted for doing the needful list up to 4 weeks as right.
May please, your lordship. I beg to mention item number 27, man. I'm supposed to file my amended petition. 2 days may be given. I'll file that amended.
The
petition.
order was passed last date, madam.
Yes, ma'am. Due to some inconvenience,
Uh,
2 days, while
Mrs. Ega and standing counsel, standing senior government counsel,
CGC, ma'am.
CBC, comma, CGC, raise for and is granted further opportunity of 2 weeks to file the amended cost title.
Your lordship, item number 41, your lordship.
Hmm.
I am mentioning on behalf of Mr. S.C. KL, your lordship. Today morning, his leg was injured due to some small accident, your lordship.
Okay.
So may I pray for accommodation for
It
the
is
day?
stated that standing counsel income tax department, Mr. KL, has suffered an injury. Thus a prayer is made to adjourn the matter, list up to 2 weeks as prayed.
That's the same prayer for item number 52 and 53, your lordship.
52, same prayer, 52 and 53 also,
Obliged.
2 weeks.
May I please, your lordship? I beg to mention item number 36, my lord. I was engaged in for respondent number 6, my lord.
Hmm.
Director ISST. But in the meantime, my tenure is already been over, my lord. The institute has already initiated the proceeding for new appointment, my lord. At least my
For
lord,
the ESIC,
the IASST, one autonomous institute, my lord.
all right, and counsel, Mr. Your good name, please?
D. Gogoi.
P. Gogoi.
D. Gogoi.
D. Gogoi submits that he was engaged in this matter on behalf of the respondent number 2,
6.
so 6, so and so. But his engagement, his term has come to an end. The establishment has started process for engaging another counsel.
Yes.
Thus he seeks deferment of the matter by 6 weeks.
Yes.
List up 6 weeks as prayed.
All right.
So as to enable respondent number 6 to engage another counsel in this matter.
All right.
May please, your lordship.
Lord, I want to move an urgent writ appeal, my lord, on Thursday. But the difficulty is that, my lord, it is against the order passed by my lord Justice Chaudhary.
You will grant permission, it will be listed in another division bench.
My lord, I'll just place them.
You just give the permission, then the rest will seek instruction for listing.
Highly obliged.
May I please, your Lordship? I beg to mention an IA for listing on Monday. It relates to PIL, and PIL involves illegal sand mining in a
All right,
river.
list on. But that will come before the environment bench. No,
My lord?
that will come up before the environment bench. No,
No.
all right, Monday.
Monday.
Very well.
Obliged.
Supplementary list for judgment, item number 1.
The appeal is allowed. The impugn order is reversed.
Highly obliged, my lord.
Daily list for orders, item number 1 to 19.
Let's prefer a bench of which Honorable Justice Eddie Chaudhary is not. Why have you not taken steps for service?
My lord, on the last occasion, my lord, when the order was reflected, though there was a deliberation that Dusty will be order directed, my lord. The word Dusty didn't come, my lord. We have prepared the notices, lordship will direct us to go to Dusty, my lord.
We can't order today. We'll have to form another bench for that. Mr. Taki, list these matters, maybe tomorrow at 2 o'clock, we'll constitute another bench. Restrictively, for this formal order of notices, we'll constitute another bench. Or tomorrow that EB is coming up now. Environment bench will come up tomorrow.
Yes, yes.
So you list these matters tomorrow in that bench, just for the purpose of notices. वो तो नहीं रहेगा। Mr. Suman Sham, deputy CM. Oh. All right. List before another bench tomorrow. Okay. Okay. Of course, you can't.
Item number 20 to 23.
Please, Your Lordship.
Yes.
In item number 20, on the last occasion, my lord sir directed us to take steps upon the respondent number 49.
Yes.
So subsequently.
You have
we have taken the
published
step-
the notices.
Yes, ma'am.
Notices have been served on the respondent number 49. Publication of notices has been done for effecting service on the respondent number 49. The service is presumed to be completed. What is the IA about?
IA is for implement of parties, my lord. The challenge was to a selection process for sub-inspector of schools.
But
my lord.
those selected candidates, they have also filed appeals.
Yes, my lord.
So you have implemented those persons only.
No, my lord. These are different. Those candidates are from 2000, selection from 2005.
Okay,
These are selectees of 2014.
14. All right.
These persons have to be implemented.
All right. The interlocutory application number so and so. What do you say to implement? Has been preferred by the appellant hearing, seeking implement of 81 candidates who were declared selected as
107 candidates, my lord.
Huh?
107.
107 candidates who were declared selected as sub-inspectors of schools pursuant to recruitment notification issued in the year 2014.
2037, 2015. my lord.
30th,
7, 2015.
30th, that is a selected, that is a select list. Recruitment notification is of 2014.
Notification is of 2014. my lord.
2014. We are satisfied that the persons sought to be implemented are necessary parties in the matter. Hence, the implement application is allowed. The connected writ appeal number 239 of 2017 shall be listed for admission. What about the other two appeals? What are these appeals? This
Connected is
Praveen Chandra Abha,
These are
same, my
connected
lord.
details.
Connected, same impute order is there.
same.
Same.
You are the selected candidates or what?
Yes, I have been selected, appointed, my lord.
All right. With the connected writ appeals. What happened to the recruitment of 2005?
That is still there, but they are working on.
They are working.
They are working.
There is no challenge to that recruitment.
There was a challenge that was dismissed. There is a stay of operating laws.
There is an appeal in that also.
Yes, yes.
Which is that appeal?
These other two appeals also. Item number.
No.
No, these are of 2014. We are asking you of 2005 also.
There is no
No litigation pertaining to that.
litigation for that bench.
Okay. Because this was interfered on the ground that there are no cadet post of sub-inspector
Yes.
Yes, yes.
after 1 week.
Right.
List.
Item number 24.
Amended cost title. The amended cost title, as directed earlier, has not been furnished. Needful be done within 3 days.
Hello.
Office to proceed there.
Item number 28.
What happened? Service,
Lordship, we have taken steps on 6th of June, your Lordship.
I'm for 3 on the lot.
only 3, and council, Mr. Soin states that steps for service upon the respondents have been taken on 6th June.
Lordship.
The notice is as per the office report. Notices for effecting service on respondents numbers 1 to 6 have been issued by registered post on 21st July 2023. Madam so and so appears for the respond number. Your good name, madam?
B Sharma.
V. Sharma appears for the respond number 3. Union of India, Central Government Standing Council, the backward classes na commission की तरफ से है. Principal Secretary Social Justice, Mr. R.K.D. Chaudhary, Deputy SGI, appears for the respond number 1. Standing Council, Department of Social Justice and Empowerment, appears for the respond number 2. Thus, notices of the response numbers 4, 5, and 6 be awaited for 3 weeks. Names of planets, Standing Council, and Deputy SGI shall henceforth be reflected in the call list. Copy of the writ petition be provided to them.
Item number 29.
What happened to 28? This was 28 only. Okay. Hmm. Yes.
Similar the fishery matter, whereby settlement was made for a period of 7 years. The settlement for 7 years.
Mhm.
Now, my lord, I filed a writ petition before this honorable court. This fishery was retendered by the government. Now, in the retendered, I participated.
Mhm.
Technically, you have to qualify. Once you are technically qualified, then opening of the price bid. Technically disqualified.
Your
technically
this rate appellant
disqualified.
was technically disqualified.
Disqualified. I didn't know what ground I was disqualified. RTI was made.
Hmm.
And I found that Baki's certificate, which was given, was not updated. It
Not-
has to be validity for a period of 90 days.
Okay.
Which the original tender which I submitted, that I submitted. That I should not have submitted, that I submitted.
Mhm.
So, my lord, I filed a writ petition before this honorable court. Writ petition, my lord, specific ground was there, taken by me. Writ petition, if your lordship for a moment, take that ground in the writ petition. Kindly see the writ petition at page 58.
Yes, please.
I'll say what my ground.
Mhm.
58, para 12. That the petitioner state that non-submission of Baki's certificate cannot be fatal to the petitioner as the petitioner already deposited that no due certificate to the AFCCL.
Why was the earlier tender process cancelled?
Earlier tender was cancelled. I don't know the reason why the
But
earlier tender was.
That tender process came to an end.
No, no.
If you are participating in a
No,
fresh
I-
process,
I participate, no. Second retender.
that's what, so it
I
is
participated.
for your purpose, it was a fresh tender.
No,
right.
it was, I participated in the first tender.
Understand?
They
But the
cancelled it.
First tender was cancelled. It is non-existent. Why they are required to
No, I'm
consider?
right. No, that's not my point. My point, what I have taken, suppose Baki's certificate I have The update was not given.
So the Bakizai certificate had to be valid for 90 days
Yes,
in
correct.
reference to the present tender.
Present tender, right?
That was
Present-
not there, your admitted case.
Right. My
Then-
lord, right. But what I am saying, that is not a fatal. That is not a fatal, I am saying. Because there is one judgment of our division bench, my lord, which my lord will kindly see. I'll take your lordship.
Let us come to the reason of your exclusion.
I'm sorry, my lord.
Let us come to the reason of your exclusion. Where is that reason as to why your technical bid was
Yes,
rejected? Where is that?
my lord, kindly see the order of the High Court, my lord. The order of the learned single,
Single judge. Let's see.
the order of the single judge.
Yes.
Which, my lord, start from 113.
Hmm.
Your lordship, I'll not trouble that. Para 8, kindly see.
Yes, please.
Para 8. Lordship got it, para 8.
Mhm.
Taking into account at page 118, taking into account that the decision in the introductory application will touch upon the merit of the petition. The instant it may taken up for disposal in as much the issue involved herein as to whether interference article today is called for in respect to the rejection of the technical by petitioner for want of updated Bakizai clearance certificate.
Mm.
As already noted herein, clause 7.4 of the tender condition clearly mentioned that submission of the update Bakizai clearance certificate. It was also mentioned in the same clause itself that without the submission of the update Bakizai clearance certificate, tenders had not be accepted. From the bid of the petitioner, which was being placed before the court by the learned counsel of the AD, it is apparent petitioner knew about the clause 7. Then also submitted expired Bakizai clearance certificate.
Mm.
Now, my lord, the finding at 13 paragraph kindly be seen, my lord, at 121.
Yes.
So in instant case 7.4 of the term categorically mandate, so and so it was also mandated. The learned single judge said it is not up to the court. Because these are authority who has floated tender, they are the best judge to know.
There
Where is
there
the
is nothing
decision?
to be judged, Mr. Das.
Yes.
The condition is very clear, up to date Bakizai. Sir.
Now, my
Now,
lord,
let's see the revision
my
and
lord,
judgment.
now I'll say,
Yes.
my lord, one judgment, I lordship always points out Abu Talib judgments
Ji.
that out of our division made at page 122.
Let's see.
122, sorry, not 122. I'll just need to go to
122 only.
I know. First, your lordship will kindly see at page 40 kindly see. I'll trouble your lordship with 40. 40, page 42, my lord. This is about 42. My lord, after 12 lines from top, after 12 lines from top,
Mm.
after 12 lines, after considering,
Yes,
lordship got it?
please. Yes, please.
At page 42, after considering the rival contention, we are of the view that requirement was submitting Bakizai clearance certificate could not be taken as a rigid requirement. It is not a case where level playing field has been denied, nor a case where loss has been caused to public revenue. In exercise of jurisdiction under Article 227 Constitution of India, this court does not sit in appeal over decision of an administrator in giving a contract unless there is illegality, irrationality or procedural irregularity as laid down by the Honorable Supreme Court.
What precisely was the condition of the tender in that case? Do we have any idea?
So, my lord,
What precisely was the term and condition of the tender
in
document?
that case, in this case.
Do we have any idea in
No,
Abdul Saleh?
Yes, I know.
Was it a mandatory requirement
No,
as per the NIT?
yes, it was a requirement.
How can we presume, sir? Let us see that.
No, that
NIT.
your lordship can call it and see it in
Why?
this case.
Why should we do that?
No, my lord. in
Question
this-
here is, Mr. Das,
No,
whether the condition has been considered by the court or
now,
not.
now my lord will kindly see for a moment.
Yes.
Now, what our division bench, coordinate bench has decided in page 122. 122,
Yes.
in respect of my lord statement, which is made in para 12, I have shown my lord.
Yes, let's.
Kindly see at page 135 at para 14, my lord. Para 14, lordship got it? At para 14, at page 135.
Hmm.
In so far as the Bakizai clearance certificate is concerned, settlement authority rejected the same on the ground the same ought to have been issued by the Deputy Commissioner Boaigaon or by DCM Golpara. A Bakizai clearance certificate is required to ensure there are no dues payable by an applicant bidder in respect of any revenue to the government. In short, the Bakizai clearance certificate can be termed to be a no due certificate issued by the competent authority of the government. The petitioner submitted a Bakizai clearance certificate issued by the Bakizai officer of a cooperation department, not Salmara, which are rejected by the official respondent. A bare perusal of the Assam Fishery Rules 1953 reveals that there is no specific requirement regarding submission of Bakiza clear and notice. However, considering the fact purpose of settlement of fishery by the government is to earn revenue, a no due certificate cannot be considered be totally irrelevant for the purpose of settlement of fishery. Here in this case, my lord, a no due certificate was submitted.
Wrong authority which issued. There's a difference. It is not even for the period which is required, Mr. Das. The wrong authority issuing the certificate that can be taken care of by finding out whether any dues are there or not. But herein it is not even for the relevant period.
No, my lord, what the learned single just, my lord, what I understand, the judgment of the division bench, a no due certificate, my lord, what is no due certificate, my lord? It is only to inform that I don't have.
I don't have any government dues
Yes,
outstanding.
government
Yes,
So,
yes.
my lord, that has to
For
be.
the relevant period. But
My
if you are,
lord, my lord, relevant period I have given, my lord, that no due certificate.
no,
Let
you
them,
yourself say it is not for the relevant period. That's your
My
own
lord,
case.
my lord, kindly see at page 67, my lord. These are the list of documents.
That's right.
These are the list of documents which I have submitted at page 67.
Yes, please.
When number 68, kindly say, no due study in favor of AB submitted.
Previous 90 days.
So let them say that I have not submitted, that the government has to say.
That is what you are saying,
Yes, my lord, I am saying,
Mr. Das. That is what you have said, that your certificate was not for the relevant period.
my lord, that
90
is-
days.
That is Bakiza clearance certificate.
Bakizai, that's
Now,
what you are
what the
saying.
learned division bench says,
Hmm.
my lord will kindly see what division bench, coordinate bench says
Yes.
at page 135.
Hmm.
Now here, 135, the Bakiza clearance certificate in this case, my lord, at page 135, was not taken, was rejected, because that officer who should have issued has not issued. But what the learned division bench said, in short, the Bakiza clearance can be termed to be a no due certificate.
Yes.
So here I am given
No
a no due
dues for a
certificate.
period of last 90 days.
Yes,
Whether your certificate in this case is compliant of that.
but no,
requirement.
no due certificate is a different affidavit we have to file. That I have no due to the government. And no due certificate, my lord. There are two things. Bakiza clearance
If
certificate.
you see para 14 on page
Yes.
135, the
Yes.
division bench holds that Bakizai is nothing but no dues.
Yes,
That is what Bakizai is.
yes.
No, if you have not provided no due certificate for the last 90
I
days.
provided. My lord, there are, I could not
Okay,
understand.
okay.
There are-
Now let us see the
There are two
reason
things.
for your rejection,
My
please.
lord, there are two things which
Yes.
I have provided.
Hmm.
Well, let it make very clear. Now, one is Bakiza clearance certificate, which the authority says that it is not for the 90 days. It
90
expired.
Yes.
Simultaneously, I have given a no due certificate also. Update no due certificate. This is what I am on.
Whether that no due certificate was required under the NIT.
Yes, yes. this
Let
is
us
the
see,
term.
let us see
At
the
page
NIT.
67.
All right. Let us see the NIT then.
In the page list of documents. list
Let
of
us see the NIT, sir.
NIT, my lord. And my lord, at page 69 in SMEs, this is what you have to just submit. Their form, my lord.
Hmm.
Their form. Now, type copy in English, we have given at page 67.
Yes.
So requirement, 7 is Bakizai, 8 no
Is no due certificate.
Yes,
Okay.
this is what I am on, my lord.
So Bakizai is in relation to dues with the government,
Yes.
and no dues is restricted to AFDC.
AFDC.
So there's a
Is
difference.
a AFDC tender, my lord. This is an
Doesn't
AFDC
matter.
tender.
They require that you should not have any dues with the government even.
AFDC tender, there is no dues, my lord. This is what,
Where
this
is
is what I.
where is the Bakizai certificate defined?
Yes,
Let us know.
Bakiza certificate,
Where is that certificate?
I-
What is the
I'll show
language
that.
language of the certificate?
I'll show it there.
Let us see.
My lord. That your lordship will find at page 39.
Yes, please.
My 39. Lordship got a 39.
Just a moment.
This at page 39.
Mhm.
This
So
is a
this is a general certificate clearing you of all dues with the government. That no dues is restricted to APDCL. They want a broader spectrum that you should not be having any dues.
My lord,
PDR. Yes. Government. revenue.
my lord will kindly see page
Hmm.
39, my lord.
Yes, we've seen that.
Page 39. Kindly see the date, my lord. This is
10/5/22.
10/5/22.
Yes. And when was
And
the
then
NIT
this
issue?
is valid for 90 days. So if this still,
And when was
10
the?
NIT is 22/8/2022.
So
NIT.
that is
So
beyond,
that's what,
beyond the period of 90 days.
that's what, I am not, this is, I am not saying, my lord, that I am not arguing. What I am saying, that requirement, my lord, it doesn't become a fatal. It is not a fatal. That is what the division bench says. It is not a fatal because there has to be a competition. I am not saying, my lord, it is not a fatal. It has
Okay.
to be not to be construed as a rigid.
Let us.
It
hear
is a
the-
flexible, it is to be construed.
We
That was the division bench.
We
said.
understand.
In
Yes.
Abu Talib case.
All right. Okay. Yes. Anything else to say? Just.
And my bidding, the price is more than them. This is one of the factor, my lord.
All right. Okay. Yes. You represent the FDC? Yes. What-
Lordship, the
How do you get beyond the judgment of Abu Talib?
Lordship, that part is clearly made, page number 117, Lordship. The single bench-
117.
The single bench has defined it. The learned counsel for the submitted that judgment of the division bench of the court dated showing to Abu Talib does not apply to the facts of the instant case in as much as the fact therein was to the effect that the tendering authorities therein did not consider the Bakizai clearance certificate to be essential condition and granted the contract to the writ appellant. In the Abu Talib case, the fact is that the tendering authority did not consider the Bakizai certificate to be not required.
Was it the discretion of the tendering authority to do so? When the requirement of the document is there in the list appended to the NIT, whether the tendering authority could have done that?
Lordship, tendering authority is here, Lordship, in this case, Lordship. Here in this case, Lordship, this bidder has participated in the tender process, signed in the tender documents. And after that, can they turn around and challenge the tender condition, Lordship, tender with documents after participating and after rejecting, Lordship? At this point, this bidder has no right, Lordship.
Right.
As long as concerning this,
No, he says that he has filed the Bakizai certificate and he has also given the no dues certificate.
no dues.
He doesn't say that the condition is wrong. That is not their case.
Lordship,
That this condition, they are not challenging the condition.
Lordship.
They are saying that the rejection is wrong because Bakizai certificate is not an essential part of the NIT. That is what their argument is. No outstanding of the government should be. That is what the satisfaction is.
And then again,
Because in this actual aspect was that they examined it, the report that there was actually no use. Yes.
Bakizai clearance
One
certificate
second.
will specify
whether
whether they have any
private
dues with the bank.
Private party has to be present in this case because
They are not represented.
no, I
He
think
is,
you know,
They are there now.
Goswami.
my lord, he is important because during when we file a-
Represented, they are represented.
His senior is there.
It's okay,
Senior is
fine.
there.
You are representing the private party.
Then it's fine. That's why I wanted to clear because pendency, when I lost the case, then an award was passed, I made a party to that. That's why I'm saying that they are very essential in this.
Yes, of course. Yes.
Lordship,
Hmm.
by Bakizai clearance certificate, it will clear whether they have any dues with the bank
Now,
everywhere, Lordship. That will be
the
clear.
bigger issue is whether the rules say that any Bakizai certificate is to be is to be appended to the NIT.
Lordship, Lordship, rules, fishery rules is not applicable in our case, Lordship.
Not applicable.
Not applicable.
Why?
Full court has opined, Lordship.
Or let's
Fishery
see.
rules are not applicable. There are number 16, Lordship. Some fishery development Commission has a sole authority in jurisdiction to lease or settle the fisheries which have been transferred.
Paragraph.
Para 16. Last part. Para 15 and 16.
Yes.
May I read, Lordship? Now regarding the application of the fishery rules in the matter of settlement by AFDC, we hold that although AFDC is a state under Article 12 of the Constitution, and it is 100% government enterprise, the provision of Assam fishery rules are not applicable in the matter of settlement to be made by the AFDC.
Yes.
Thus, AFDC does not have the power to make any direct settlement of fisheries as the state has got in view of the provision rule 12 of the Assam fishery rules. We are in full agreement. So Lordship, we as an employer has the right,
Right to impose whatever condition you think proper.
Lordship, it's been
Right.
decided by the full court, Lordship.
अबू तालिब वाला judgment. नहीं, Abu Talib.
In Abu Talib, Lordship.
Just a moment. We want to just have a relook at the judgment. What is the page number of Abu Talib, Mr. Das?
Page 40.
40.
It is in favor of, actually, it is supporting us only, Lordship.
Hmm?
It is supporting the tendering authority, Lordship, Abu Talib.
Abu Talib, how do you say so?
Because Lordship, in the Abu Talib, Lordship, kindly go to the, I'm reading, after considering rifle condition, we are of the view that the requirement of submitting Bakija certificate could not be taken as a rigid requirement. It is not a case where level playing field has been denied or a case has been caused to public revenue. In exercise of jurisdiction under Article 226 of the Constitution of India, this court does not sit in appeal over the decision of an administrator in giving a contract unless there is illegality, irrationality or procedural irregularity as laid down by the Honorable Supreme Court in Tata Cellular of India. If after taking into account all relevant here, Lordship, so the writ appellant court has not
Interfered in the
with
decision.
tendering, the decision of the tendering authority, Lordship.
My lord will kindly see from 41, page 41 kindly see, my lord. The issue was a Bakizai, page 41 of the facts of the case. Learned counsel, the lordship got it at page 51. At page 41, learned counsel for the appellant submit defect is not submitting Bakizai is a curable defect. If a public authority allowed the defect to be no prejudice was caused of writ petitioner or the public revenue, such an interference by the court was not called for. Reliance has been placed by so and so.
The view of division bench that Bakizai certificate is not a mandatory requirement in NIT. How do you surmount that view? How do you? Yes. Yes, please.
That's it.
How do you get by this judgment? This is a ratio of the division bench judgment. We are bound by it.
Here, Lordship, after level pay.
After considering the rival contentions, we are of the view that the requirement of submitting Bakijai clearance certificate could not be taken as a rigid requirement. And the subsequent division bench judgment says, if no due certificate is there, that is sufficient.
Lordship,
So they have-
the subsequent division bench judgment is not concerning us. It is government and fishery rules are applicable in that subsequent judgment.
No, that is also APDCL.
No,
No,
Lordship. It is
So it is
government
not of
and
APDCL.
where fishery rules are applicable, Lordship. Here it is specifically stated, Lordship.
all right. AFDCL, Sanjit,
In the subsequent judgment, Lordship.
now that is not AFDCL.
No, Lordship.
That is not AFDCL. Yes.
Lordship,
You're right.
Lordship, here in the instant case, Lordship, my submission is to leave aside, Lordship, the requirements of the challenging the concept that the bidder has signed in the tender documents, agreeing as per contract, agreeing all the terms and conditions, and participate in the tender process. And after being rejected, they came to this court.
So obviously, they said that the rejection is wrong. They are not challenging the condition. They said that the rejection is wrong.
Whatever they signed the documents in the tender.
Understood. But then they say that you could not have rejected me as my Bakijai certificate is falls short of say 10, 20 days. not more than that even.
But it was specifically stated in the tender bid documents, Lordship.
What?
In the tender bid documents, it is in the order, they have not.
That is what the division bench has held, gentlemen, that it is not a mandatory requirement. And if he has offered a higher rate, the loss to the public revenue is there apparently. He has offered a higher rate, no dispute.
No. No, that is, we have not opened the, open his.
You have not opened his financial bit. He must be knowing what he has offered. He must be knowing.
Yes, we have not opened it. Lordship.
You may not have opened. What is your offer, Mr. Das? What did your client offer?
My lord, my offer is 65 lakhs.
And what was the fishery settled at?
65, 80. His rate is 56 lakhs.
10 lakh rupees difference.
65 lakhs, 80,000.
Yes,
That is paid
all right.
1 month.
What do you say, gentlemen?
Sir.
Yes, please. Yes.
My submission of Lordship, we have participated in tender process.
Right.
There is a specific condition in tender notice that up-to-date bucket certificate is necessary. Up-to-date bucket certificate necessary. And Lordship, the authority has evaluated the tender process, and thereafter, Lordship, our tender was open, his tender was rejected.
Yes.
At Lordship, the feasibility. That thereafter, Lordship, financial bid has been opened. Our bid was found to be highest. I have been allocated the fishery, and I have given the case money and everything, Lordship. And the division bench that has been pointed out by this by the council, Lordship, senior council, that is regarding Assam fishery rules, Lordship.
No, Abu Talib is not regarding of Assam fishery rules. It is AFDCL. Read page 40. Page 40 of the appeal.
Is 40. Is 40 what I said.
Fisheries department is not even a party in that rate appeal.
Abu Talib case, Lordship.
Yes. Why should we take a different view? The division bench says, no due, this Pakiza is not a mandatory requirement. What was the affidavit you had given? Your client had given with the tender? What was the affidavit?
Affidavit.
You said that you had given an affidavit.
Yes,
With
that
the-
is with the record, my lord. It is not the record.
Have you got the record? Day after tomorrow. Bring the report, the record day after tomorrow. Day after tomorrow. Learned Standing Council, if AFDCL shall keep the original record available on next date, re-notify on 27th.
Quickly open.
Item number 30 and 31.
Transfer wale.
31, I think it's differently on lordship will take up.
31 is a different one. Okay.
In fact, my lord, lordship take this matter with that because I think arising out of the same proposal.
Same proposal.
Yes.
Yes, that is the reason.
Yes.
Then we'll hear it separately, not an
Yes.
issue. Yes.
My lord, in this case, at page 24,
Mm.
the appellant was transferred, my lord,
Mm.
at serial number 7.
Serial number 7.
Yeah, Nemo Rina, that's the appellant. She
Page
was
number?
page 24, my lord.
Yes, please.
Yes,
Yes.
serial number 7.
Mm.
Now, she was principal in this girls' higher secondary school, Kanubari, London.
She or he?
He, my lord, he.
Mm.
And my lord, transferred as deputy director of secondary education,
Leopard.
so and so.
Yeah.
He will join in the last part of April. My lord,
Mm.
it was a series transfer.
Mm.
Then, my lord, at page number 26,
Yes, please.
the appellant was released
Relieved.
from that school,
Yeah.
my lord.
Then, my lord, at page number 27, the appellant joined on
Yes.
28th of April.
Yes, please.
Then at page 28, my lord, same date. Now.
On the very date of joining.
Yes, I came to know subsequently that the appellant, so-and-so retained as principal Longding. And in my place, my lord, the respondent number 5, she has been brought in,
Okay, so you're
He has been
basically
brought-
your transfer order was cancelled.
cancelled.
So why are you worried about it? Why are you
I
agreed
have
by that?
joined, my lord.
All right, you will
I
get.
never made any request to anybody, unlike the respondent number 5.
No,
that's
wrong. That's wrong.
Just hold on, sir. You will get your chance. Have you felt anyone has perceived that we don't allow hearing, opportunity of hearing to a learned counsel?
My
Why
lord
this
will
anxiety?
My lord will
We are,
kindly.
we are
come-
rather anxious that we are not engaged for the whole of the day.
I'm sorry.
Ah,
We are at a loss to find any counsel after 12 o'clock. Yes,
My lord will kindly come to page 32.
yes, please.
My learned friend says that.
So there is, as per you, there was no question of retention because you had already joined.
Yes. And my lord, there's a judgment of this
Page-
honorable.
page,
Page number 32.
Yes.
Kindly see, my lord, this is a proposal. Proposal for transfer and posting of DDSC received from honorable minister, MLA and person concerned on various ground may be seen as details shown below.
And that is what we were
Yes.
worried about the other day in
In
the
the
other
other
matter.
case.
Yes.
Yes. Now, my lord will kindly come to page 38.
Yes.
Serial number 6, Ubi Lombi, that's the respondent number 5. Then 1, 2, 3, 4, 6 column, my lord. And EO note addressed to Honorable CM Arunachal Pradesh received from Gokar Basar, Honorable MLA, 29 Basar ST with request for transfer and posting of Ubi Lombi principal so-and-so as DDSE Basar in public interest. It is stated that the officer is very sincere, good administration, etc. Now, last column, my lord, regarding the appellant. Naimo Rina Principal Kanubari is under order of transfer and posting as DDSE, white order of transfer dated so-and-so. So this was also indicated, my lord. Then, my lord.
DDLC Basar.
Ah,
But you were
say
posted.
The long thing is a Basar, my lord.
Is
Same
Basar.
thing. Yes. Please come to page 39. Serial number 6, somewhere towards the bottom, my lord.
Yes.
Can you see? Ubi Lombi principal so-and-so applied for DDSC Basar. However, so-and-so is under order of transfer as DCS. She not only applied for Basar, she also approached to the MLA. Eventually, my lord, at next page, note number 98, second sentence. As regards serial number 6, one Naimorina principal is already under order of transfer to Leoparda district as DDSC, which may be seen at page so-and-so. Eventually, my lord, at page number 45, DSC Chief Minister approves, my lord.
45.
Page
Yes.
45. As stated above, I am initiating this under note regarding transfer and posting of Ubi Lombi, who is presently posted as principal so-and-so to Leoparda district at DDSC of Leoparda district. Lombi is very sincere and good administrator in education sector. Moreover, has already served as deputy director DDSC in many districts under Arunachal. Apart from the above, general public of the Leoparda district also apprises me for transfer and posting of Ubi Lombi as so-and-so. Hence, I fervently request the Honorable Chief Minister to consider the transfer and posting of Ubi Lombi principal so-and-so as DDS in Leoparda district on public interest.
Yes.
Gopar Basar, that's the local MLA, and Chief Minister approved. And this is how, my lord, the transfer order has been passed. Now, my lord, there are two aspects, my lord. First of all, the learned single judge, I challenge the order of transfer, my lord, and which was rejected, the writ petition rejected, amongst others on the ground, relying on that, my lord, Supreme Court judgment in that Muhammad Masood Ahmed. Well, that was a case where there was a complaint which was supported by the local MLA, MP. This is how the transfer order was passed. Now, our High Court, there is a judgment, my lord. One, it is presumed that when an order of transfer is issued, it is always in public interest.
Yes.
Therefore, if that order is to be recalled or cancelled, then there has to be an overwhelming public interest which must be disclosed. In fact, there is a judgment by Honorable as a H.K. Sema, Honorable Justice, as a my lord, single judge of this Honorable Court has passed the judgment. 1997, 1 GLT 140. My lord, may kindly come to paragraph 8. This court in a Ketenov decision has held that for cancellation, modification or keeping in abeyance of the transfer order, public interest must be supported with sufficient reason necessitating for passing such order. The view taken by this court has a rationale behind it. Once a transfer order is made in public interest, court normally do not interfere unless the order is passed with mala fide or against the statutory rules. Only way open to the aggrieved government servant is to file a representation before the competent authority to redress his grievances. But this court insists that for cancellation, modification, or keeping it in abeyance of such order must be supported with sufficient reason because transfer officers are always made in public interest and after elaborate exercise as to who should be transferred where in the exigencies of administration. While processing the transfer order, various factors are taken into consideration. One such factor being duration of the stationing of one officer in a particular station for a long time. If an officer is posted in a particular station for a long time, no doubt that he also acquire a considerable knowledge about administration of the area, but at the same
Basic
time,
idea is overwhelming public interest must be reflected.
something like, my lord, the doctrine of promissory estoppel, my lord. When you issue an exemption notification, it is in public interest. Now, if you want to
Recall-
reside from it, it must be supported by an overwhelming public
Yes,
interest.
yes.
Now, my lord, the request of the MLA cannot be an overwhelming public interest.
That's right. That's right.
In my humble submission, my lord, therefore, the learned single judge has committed an error in not interfering with the order of cancellation.
What is the status? Where is your client now?
My lord, I
He has
have
been
also
relieved?
joined. He claims he has also joined.
Okay.
I have joined. I have
You're,
shown the
you're
papers.
drawing salary from that place only.
No, that
Leparda.
stage has not come, my lord, because it's only very recently.
Joining was in April.
April.
Now we are in July.
That instructions I'll have to take. That instruction will take. my lord.
All right. Yes.
That's my humble submission.
Yes. Mr. Goswami. What is the overwhelming public interest in cancelling the order of transfer once it had been executed?
My lord, number one, my lord, there was no application from the private respondent. It was a recommendation by the MLA, my lord.
So only and only the recommendation.
Yeah,
Does the recommendation
No, my lord.
assume the role of public
My
public
reply
importance?
to that
Public
is
interest.
para 12 in my affidavit.
Yes.
That will be at page 80 to 83,
Yes. Would you be going beyond your order, language of your order?
my lord.
Would you be trying to go beyond your record?
My lord, yes, my lord, my lord.
Yes.
It was a,
All right.
it was
That's
a,
good.
It was a, my lord, comprehensive decision. It's a conscientious decision taken.
Mr. Goswami, comprehensive decision also need not be a reasoned one, a justified one.
My
If
lord,
it is rampantly at the done at the whims of the MLAs,
my lord,
why
no,
should be sustained?
my lord,
You
my
know the
reply-
consequence, Mr. Goswami.
my lord.
Who will bear the 1 month salary this person will get as a result of the order
He
being
didn't
cancelled?
join, my lord.
He joined.
He filed a joining report, but he was not given charge.
He
my
was
lord.
relieved. It is a fact.
My lord,
He,
let me
Mr.
clear-
Goswami, just hold on, please. He was relieved. He proceeded to that post, that place. Moment he does that, he is entitled to 1 month salary,
my lord,
basic salary,
my lord,
80% of 1 month
my
salary.
clarification to that, my lord.
Yes,
My lord, he was directed to join by the end of April.
yes,
He had filed the joining report in the DC's office on 20th of April.
yes. By the end of April. So
By the
20th
end
is
of-
good enough.
The meaning is this, my lord, because the incumbent was to retire by the end of April. So he could, so he could take over chance by end of April.
Yes.
That is the background, my lord.
Yes.
But before that, he had proceeded there. Maybe, my lord, because he had.
Can you justify this mess which you have created in this manner, transferring people here and there and then recalling the orders rampantly at the whims of the MLAs? What do you want? Do you want this court to comment on what kind of administration you are
I'll
giving?
just place the records, my lord. I'll not say
Mr. Goswami, you really take your instructions. Do you want this court to comment? Does your government want to do that?
Your lordship will kindly allow me to read from my this pleading.
Very well, all right.
Just one line,
All right, then,
just
then,
one.
and then if
My lord,
that, that is the situation, then all right.
my
Then you invite our comments on the manner in which the administration is being done.
But my lord, from record, I find my lord, there was no application from the the present incumbent in the post. There's a recommendation is there, my lord, from the MLA. And
You're not applied for.
please, before the court.
My lord, page 39, my lord.
No, where, RTI. records
Yes,
show.
yes. Serial number 6, my lord, at page 39.
Yes.
Fubi Lombi principal so-and-so applied for DDSA Basar. Now he says he has not
My lord,
applied.
Where are you reading?
Page 39, my lord.
39.
Yes.
Yes.
Serial number 6.
Yes.
Fubi Lombi principal DK Girls Higher Secondary School 0 has applied for DDSA Basar. Is the government note got under RTI?
Just hold on. When was the first transfer order passed? Your transfer order?
Yes, by transfer order.
20th
is at
April.
Page 24.
24.
Yes.
Just hold on. 15 November 22.
Yes.
So that order was already in existence.
Yes.
In the meantime, one more person makes a request, files an application. Then he manages to get the support of the MLA, and you just change the entire decision.
No, my reply to that, my lord, in the affidavit, that was not the reason, my lord. Your lordship will kindly.
Reason is that he is a very good administrator, right?
Yes, my lord, he had
Is this person,
experience of.
is the appellant a bad administrator? Is it
He was serving as a principal of the school, my lord, whereas this gentleman, my lord, he served as DDSA for quite a long time. in different
principal,
places.
having remained a principal, a person will never aspire to become a DDSE.
And
You mean to
that-
say?
And that, my lord, particular district, my lord.
Release kiya na? You say that he joined on his whims, right? He had no authority to join. Read page
My
26.
lord, he
please.
could have
He
joined. my
could
lord.
have means what? Read 26, please. Mr. Goswami, really, we are just giving an open indication, giving our mind out that
My lord.
maybe we'll be
These are-
persuaded.
These are
make-
release order
Release order issued by whom?
from the school where he was working.
Are you sure?
My lord.
Deputy Commissioner.
Deputy Commissioner, Longding District, my lord.
So once a employee is relieved, what is to do? State of flux?
My lord, this aspect is there, my lord. I accept this, my lord. But the direction in the first transfer order to him was.
What
to-
was he to do after being relieved? Where should he have stayed on? Have you provided a transit hostel for the people who are in the state of flux?
My lord, that is difficult.
Trishanku.
It was released by the deputy commissioner. He had gone there on 20th, but that direction was to join by the end, because by the time that incumbent will retire, and so that he could take over charge. So what has happened? He could file the joining report, but he couldn't take over charge. And whereas the private respondent who joined on 28/4, my lord, that is at.
So even if you go by that, even till then, the incumbent had not retired. He was to retire on 30th April.
That is correct.
Then the same situation for both.
Yes.
That is.
Again, take a call. You want this court to make comments or not?
I will definitely not want that money.
Then you take your
Let
instruction.
me present my facts.
Yeah, of course, we'll do that.
You may take a final call.
No, then we'll not stop, Mr. Counsel. Then we'll not stop. We'll dictate the order. Let the government counsel say that he wants to invite these
But
observations.
But I'm sure my lord will give.
Very well then. Mr. Goswami, all right, then he's taking that risk. Then all right, let us proceed with the matter. Yes.
Facts have not been properly presented.
All right, all right.
Let me-
That again, an aspersion on the additional advocate general, that he has not presented it properly. All right. Yes, please.
For a moment, my lordship may see page 86.
Nobody does. Nobody gets.
My lord may see page 86 first.
Yes, please.
Thereafter, I'll start from the beginning.
Yes,
There lies a catch.
yes.
It is circular dated 28th April
Hmm,
2023. And
hmm.
my lord, it reads, I have taken. My lord, respondent 5 is writing, Purvi Lomi, respondent 5 herein.
Hmm.
I have taken over the charge of DDSE Leparada district on the day of 28th April 2023 after relieving, lordship may see the name, Shri Tumo Lollin, who's retiring on superannuation on 28th April 2023.
Who has acknowledged this letter, sir?
My lord, this is the letter written to.
Who has
My lord, it was-
acknowledged this?
My lord, because my lord, till 28th April, let me explain this. Till 28th April, I will show another document.
Is your client empowered to issue a circular?
My lord, I'll come to that.
We are
I'll
asking you,
explain,
sir,
my lord.
answer that query, please. We are on that circular. You are referring to it. We are asking you a query. Does your client
My
have an
lord, it was
authority
sent- my
to
lord,
issue a circular, sir?
My lord, it was sent to the commissioner. It was after taking over the charge. I'll explain that out, my lord.
Okay,
It was sent
very
to
well.
all authorities.
Very well.
So, my lord, first of all, last part of April. Why that word is important? The 15th November 2022 order, my lord, at page 24, Lordship may see clearly, page 24. Serial number 7, that is the appellant. He has to join in the last part of April 2023. The last part of April 2023, my lord, last part of April 2023 was mentioned because in this very particular post, Mr. Lollin was holding this post and he was to retire on 28th of April, 28th of April. So, my lord, before the retirement of Mr. Lollin, this post was not vacant and nobody could have joined this very particular post. This is, my lord, point number 1 I'm trying to make.
Yes.
That is why last part of April. Now, my lord, by the same order, 15th November 22, Lordship may see serial number 9.
Where is your relieving order?
My lord.
Yes.
My relieving order, page 95.
Yes, please.
Page 95, my lord, I'm sorry. That it is not in the paper book by relieving order. Page 95, my lord, is the
Same day,
GFR 33, the form.
28th April, you relieved. 28th April, you took charge. What is the distance between Basar and Lapada?
What is the distance?
Probably
Lord,
we'll
I'll
have to
find out.
direct.
It's very, my lord, it's not far away. It would have been, it could not have been possible. Otherwise,
We
it would
don't know,
have been
sir.
possible.
We don't know. There's every possibility of your joining order having been fabricated, antedated document. Maybe we'll be compelled to make that observation also.
My lord, distance, my lord, I'll find out.
We will just find out. We'll just find out. Don't worry. Check karna net ke upar.
Because, my lord,
Basar and Lapada, distance, please.
Basar is a district. Laparada is a town, my lord, within the district. Basar is a district.
You were earlier posted at
My lord,
stationed at Basar.
by that order, I was posted at 0. My lord, 15th November order may kindly be.
So you had joined at 0 or not? Why didn't you
I
join?
joined. My lord, I joined 0 on 27th, 12, 22.
So you should have been relieved from 0.
Yes.
Where is that relieving order, please?
My lord, it's not annexed in the paper book.
Then all right, let us see that order.
My lord,
We
then
would like
let
to
it
see
be
that.
annexed on some other day. I'll bring those documents also.
All right.
Otherwise, it's difficult.
Oh, that
Two joining.
come to page 93, please.
Yes, two joining.
Come to page 93.
Yes.
How many joining reports have you created?
My lord, it is because initially, page 93.
You rest assured, sir.
My lord.
If you are not satisfied, we'll direct your client's prosecution for creating fabricated documents.
My lord, documents are
To
not
take your
fabricated.
instructions, these are fabricated documents on the face of it. What is 93?
21st
You-
April 23.
You read your relieving order at page 95. That is 28th April.
My lord, if I serially, my lord, I place everything, it will be very easy for me
Sir,
because I'm also jumping from one page to another.
Please
So
read.
I'm unable to place the facts. Lordship may kindly let me place
All
the
right,
facts,
then
my lord, my way.
all right, we'll take note of your facts and decide the matter today itself. Then there is no deferring the matter.
But my
Okay,
lord, in that
proceed.
case, the distance between Laparada and Basar.
We will
Lordship
find
was
out, don't
asking
worry.
for-
We'll find out.
But in the relieving order also,
We'll find out, don't worry. Yes.
because 20th.
We
my
will
lord,
reserve the
21st
order and
April,
we'll reserve the order and get the original
my
record.
lord, 21st.
Mr.
April,
Goswami,
my lord.
the original record must be with Mr. Chaudhary. Mr. Chaudhary, we had, Mr. Ranvi Chaudhary, we had asked you for the original record. All right. Yes.
I think I'm explaining. My lord, I'm explaining.
Very well, very well. You carry on, please.
Then, my lord, I start from page 24 first.
Wherever you want,
Well-
wherever you. Now with a clear understanding, now we are not deferring the matter.
Very well, my lord.
All right, very well.
So, my lord, serial number 7 is the appellant. He was to join in the last part of April 23. I have already pointed out that last part of 23 was because on 28th of April to 8th of April, the person who was holding this very particular post was retired. So therefore, this post was not vacant before 28th of April. At serial number 9, my lord, is the respondent
Mr.
file.
Goswami, get his relieving record right now by email. When was he relieved? We need it. Yes,
Serial number 9, my lord, is the respondent file.
yes. The appeal,
At the same
respondent-
order, my lord, he was transferred from SEPA. He was Deputy Director of School Education at SEPA,
Yes,
and he was transferred as principal to Government Higher Secondary School at Jiro.
yes.
Pursuant to this order, my lord, he
yes.
joined Jiro on 27th December 22. 27th December 22. Now, my lord, the
Yes.
next date,
Yes.
on 21st February
Just
2020.
hold on, sir. Where is your last transfer order? We'd like to read that.
My lord, this is the last transfer order.
No, the one
Zero.
which is now under challenge.
My lord, Lordship assured me that I'll be allowed to place the facts, my lord. Seriously.
Please, you are prepared to answer the queries or not?
Well, I'll answer all the questions. My lord is right to
Let us see
answer,
the
answer.
Let us see the transfer order, please.
That's 28. Page 28.
Yes.
Yes,
Page 28 transfer
Yes.
order.
my lord.
We just like to apprise you that this transfer order doesn't reflect that it is on own request, meaning thereby that your client would have taken advantage of the displacement allowance.
I beg your pardon, my lord, I'm sorry.
This order doesn't reflect that this transfer has been made on his request, meaning thereby that he will get benefit of two displacement allowances, one from coming to zero and then
My
from
lord,
0 to.
My lord, this transfer order was not made at the request of the respondent.
All
file.
right,
I will
gentlemen,
show that
all
also.
right. Yes, yes, yes. Very well.
First of all, my lord, let me explain this
Yes.
as to why this order of transfer was not made at the request of
All
respondent
right.
file. There
All
are
right.
3 documents. Lordship has seen only one.
Yes,
Let me
yes,
show 3 documents.
yes.
First of all, my lord may see
Yes,
page 31.
yes, please.
I'm showing 3 documents, one after another.
Hmm.
Page 31. Page 31, my lord, the appellant, in order to assure himself that there indeed was an application made by respondent 5 for his transfer to Leparada, filed in RTI, and asked for the copy of application for DDSE by Kubilombi. NA, not available. It is not available, it was never made. I'll come to the second document. The second document, my lord, will find in the proposal. Proposal. The proposal, my lord. Proposal. Page 32 to page 32. It starts.
Yes, please.
Now, page 32, my lord, will find note 90. Note 90. Proposal for transfer and posting of DDSE is received from Honorable Minister, MLAs, person concerned on various grounds may be seen as details shown below. Number 1, Srimati such and such, Itanagar. Lordship will see 1, 2, 3, 4, 5th column, brief, self-representation. Wherever there is representation, my lord, they have made it clear. Number 1, self-representation. Then, number 2, Srimati such and such. The brief is UO note, received from such and such. Then, my lord, 3, they have given all details. Lastly, my lord, will come to myself. Number 6,
Yes.
respondent 5, such and such. What is the brief? UO note, addressed to Honorable CM if we received from such and such. My lord, there is no application of mine. But then how come, my lord, the reference made? Then, my lord, will see the relevant page, page 39.
Yes.
It's the mischief, my lord. There are people involved here and there. Page 39. The way the language, my lord, is serial number 6. Serial
Yes.
number 6. Sri Pubi Lombi, principal such and such has applied for DDSE Basar, however, never in a principal GGSS under order of transfer such and such. In this regard, thereafter he says. In fact, my lord, admin officer, this was a mischief. There was no application by respondent 5.
Yes,
It was only the note of the MLA.
yes, please.
So, my lord, out of 3 documents, only the last one gives that indication. That indication would not make, my lord, what is incorrect correct.
Very well.
Then, my lord, will find. So, my lord, one thing is clear, that last part of April 23. In my case, I was sent to 0. I joined in 0 on 27th of December. What happened, my lord, thereafter? Thereafter, the relevant date is 21st February 23, page 45.
Yes.
This, my lord, is already seen. This is, my lord, the letter of MLA. Now, my lord, what does MLA write in the letter? He writes, I read, my lord. As stated above, I am initiating this UO note regarding transfer and posting of Sri Pubi Lomi, who is presently posting as principal at DK Government Higher Secondary School, Hapoli 0 to Leparada district as a DDSE of Leparada district. Mr. Lombi is very sincere and good administrator in the education sector. Moreover, he had already served as a deputy director of school education in many districts under Arunachal Pradesh. Apart from the above, the general public of Leparada district also apprises me for the transfer and posting of Sri Pubi Lomi as DDSE of Leparada. Hence, I fervently request the Honorable Chief Minister of Arunachal Pradesh to consider the transfer and posting of such and such 0 to Leparada district at DDSE Leparada on in public interest, such and such Goku Basar. Process my lord from Chief Minister to Departmental Minister, Education, etc., etc. Then, my lord, the discussion started thereafter. The issue was discussed at various levels. The next date, my lord, will find is 23rd of March 23. All along, my lord, appellant is keeping quiet because nothing concrete has resulted. 23rd of March 23, note 90, the page number, my lord, 32. That lordship has already seen page 32.
Yes. Yes, please.
The proposal, notes, etc., etc. Finally, my lord, in this proposal, the note, so, my lord, all this proposal and processing of the file. Here, my lord, will find the departmental minister. Then, my lord, comes the next page is page 27.
Yes.
Because developments were taking place, my lord. So, when the concrete result, namely of this entire proposal, there was a possibility that the order can be modified or is likely to be modified. The appellant then, my lord, page 27. Appellant then immediately moved. Page 27. He ensures his release on 19th because he knew that on 20th order of transfer is going to come. This indication, my lord, I'll give from this document.
Yes.
On 20th April, my lord, the order comes.
Yes.
The order of transfer straight away. But here, my lord, will find page 95 thereafter. Because, my lord, so far as the release of appellant is concerned, even if appellant ensured his release and took his release, he could not have joined before 28th of April.
Yes.
Because till 28th April, the post was occupied.
All right.
But in the meantime, my lord, that order of transfer was modified on 20th April. So once it was modified on 20th of April, it was modified, my lord, qua me, not qua, my lord, the appellant. Order of transfer was not modified qua appellant, it was qua the respondent 5. Because in my case, my lord, I had already complied with the first order of transfer, I had gone to 0.
Yes.
In his case, he was to come to this place, Leparada. After 20th of April, he could have joined, 28th of April.
Yes.
But he rushes, goes on 20th. On 20 April, he could not have joined. That joining, my lord, has no sanctity of law because post is already occupied. So after 20th of April, my lord, formally, my lord, I, page 28, sorry, page 95, I take the charge.
Yes.
because I was already relieved earlier. I take the charge on 28th. The joining report, 21st of April. The joining, because you know, page 93, I will explain this. Lordship will find 21st of April is after 20th of April. On 20th of April 20, the order of transfer is modified. On 20th April, it is modified. I am directed to go to Leparada. On 21st April, I join. But I join, I can't hold the post. I reported to the Deputy Commissioner that, look here, I have come. And formally, my lord, I joined on 28th of April. The date on which Mr. Lollin attained the age of superannuation and he retired. Now, my lord, the note of departmental minister at page 42 may kindly be seen.
Yes.
Page 42. Note 105. Lordship will see the date over here. The date is 20th April. Note 105, page 42, at the very top. Shri Pubi Lombi Principal GCS 0 is transferred to DDSC Basar, such and such, to continue. Nyamorima, that is the appellant, to continue at Kanubari Government Higher Secondary School. 20th April, Minister takes a decision. 20th April, order is modified. 21st April, my lord, I submit my joining and I formally take over the charge on 28th of April. Now, my lord, I ask myself that when the post was to be vacant on 28th of April, appellant, certainly, my lord, could not have gone and joined there earlier and taken over the charge.
What about your own client's document whereby he supposedly submits the joining report on 21st April? Could he have done that?
My lord, joining in the sense, my lord, he has
For you, the
reported.
joining is in a sense. For him, it is a fraud.
My lord, I'll put it this way. My lord, I'll explain this. To me, it is correct for the simple reason order of transfer stands modified on 20th April.
Yes.
In his case, my lord, in my case, there was no date given that on this particular date I have to move.
You must
In
have
his case,
you
my
must
lord,
have filed an affidavit. You must have filed an affidavit.
my lord, in the paper book, naturally. That, my
Have you
lord,
filed an affidavit or not, sir?
affidavit, my lord, affidavit is there of respondent 5, page
Let's-
87 to 96.
Let us see that. Let us see.
Page 87, it starts.
Yes.
I'll put it this way, my lord, fine. Let there be no sanctity in my joining, let there be no sanctity in his joining.
Just
There is no
hold on.
sanctity in the joining of any of them.
Please
But my
hold
lord,
on.
certainly the sanctity is there so far as taking over charge is concerned.
Let us see your affidavit. When did you get relieved from your zero
Page
posting?
87.
When did you get relieved?
My lord.
Read from your affidavit.
My lord, 5 onwards I will read.
Yeah,
Para
read the date, time. If you mention that I
Time
was
is not mentioned.
relieved from zero on such and such date.
That with regard to the statements made in para 4 and 5, 6 of the writ petition, the answering deponent begs to.
Probably we would be right in observing that before joining a person has to be relieved from the post.
Yes, my lord.
So let us read that pleading, please. What you are harping upon the order being issued on 20th.
Paragraph 9.
Yes, read please.
It is page 89, my lord.
Yes.
Para 6, I will just read in full. That with regard to the statement made in para 7 of the writ petition, the answering deponent begs to state that the transfer order number such and such dated 20th April 23 was issued in public interest and there is no malified intention in doing the same. Moreover, it is the prerogative of the government to transfer its employees. It's not necessary. It is further respectfully stated that in pursuant to the said transfer order dated 20th April 23, the answering deponent has joined the DDSC Liparada district on 21st April 23 and submitted his joining report before the Deputy Commissioner such and such. Accordingly, handing and taking over charge of DDSC Basar Liparada district was done on 28th
You have the
April
document,
23.
Mr. Goswami.
On 0, my lord.
All right.
My lord, here, my lord.
Yes, have
Here,
you
my
said
lord, there
so?
is no clarity, my lord. There is no clarity. In
Okay.
that, but I
Very well.
admit that.
Very well.
I admit.
Hmm.
But my lord, my only submission is
Yes.
that fine, my lord, so far as joining, my lord, fox for the goose is fox for the gander. If his joining has no sanctity, my joining also has no sanctity. My lord, the crucial date will be 28th of April 2023.
You have never been relieved from zero, sir.
My lord,
You have
as
never
per
been
my-
relieved.
that may not document.
Your pleading doesn't indicate that you have been relieved. What is the date of your affidavit? Your client would be knowing now. Your client would obviously be knowing.
Pleading is.
What
not
is the date
good
of your
enough.
affidavit?
Pleading is not.
So
good
now
enough.
we, in writ petitions, we proceed on affidavits. We
That's-
presume that that is the procedure being followed. So let us see what is the date of your affidavit.
My lord, it's not indicated.
What is the
My lord, I
date
have not-
of your affidavit, sir?
Date of
What is the
affidavit.
date on which you swore the affidavit?
Sometimes in May, my lord. એ તમને 26 તારીખે join થશે.
Yes. Very well.
Date is not, month is may not May. The date
Very
is
well.
not here in the
So,
paper book.
By then, your client must have known when he was relieved from zero.
Certainly, my lord, I'm
Yes,
sure.
all right.
that
Anything else to add?
Is, must be getting the.
Anything else to add, sir?
So, my lord, I would submit, my lord, that so far as, my lord, the appellant is concerned, the cause of action got extinguished with the modification of the order on 20th of April.
Yes.
Because on 28th of April only the post was to be vacant. Much before the post getting vacant on
Yes.
28th of April,
We have
the
seen.
order was modified itself on 20.
Yes.
And apparently, my lord, there was no application, no request made by the respondent 5. Recommendation of MLA certainly is there, but MLA in his recommendation does not attribute any malified anything against the appellant. He only says for reason A, B, C, and D, respondent 5 should be posted over there. And my lord, he happens to be a local MLA. Justice Karju, my lord, also in that very particular case of Mohammad Masood, he says he has looked into the affidavit also in that case. And apart from the complaint, there are other aspects also in that very particular judgment of the Supreme Court. Complaint was not the only basis. The judgment says even otherwise. So apart from the complaint, even otherwise, nothing wrong if the MLA, my lord, send some recommendation. There is a division bench judgment of this
Yes.
honorable court also,
Yes.
2019. I'll place it.
Yes, please.
That merely because recommendation is there, that by itself will not vitiate the order of transfer.
Yes. There's an argument advanced. Probably we might ask you to respond to that because you have said that I am not to be disturbed, but still you have to answer the argument.
I'll
That-
answer it, my lord. I'll answer.
Then you recollect what was the argument and answer.
The answer is, my lord, here, my lord, it is at the behest of the MLA. And MLA
Very
issuing such an order,
All right.
making such a recommendation has
Very well.
vitiated the order of transfer.
All right. So that is
And
the,
number 2, the application was made by me. It was on my request. And my request was supported by the recommendation of the MLA. So through this, my submission is there was no application made by me. And the recommendation of MLA, my lord, was on his own.
very
It
well.
was not at my behest.
Okay.
So far as, my lord, page 39 is concerned, my submission is this is the mischief of the admin officer. He has mixed up the two things, the recommendation of the MLA and my application. My application doesn't exist because RTI also in reply, they say not available. And
Yes.
subsequently in the proposal, in the brief, it is clearly mentioned, there is no application made by me. It is only below the recommendation of the MLA.
Very well.
And my lord, reasons apparently are given. My lord, there are 3 paragraphs. The citation, my lord, is 2019,
Yes, please.
2 GLT, page 600. It's a division bench judgment.
Yes.
I read para 6, I'm sorry.
Yes.
Para 6, my lord, at page 602. A mere perusal of the aforesaid UO note, my lord, is quoted above, of Parliamentary Secretary, dated 14/5/2017, discloses only the views expressed by the Parliamentary Secretaries, respondent 4 and 5, as to the developmental projects being hampered in the absence of a regular experienced executive engineer at PWD SIPA division, which in turn was causing great inconvenience to the people of East Tamil district. The said UO note does not spell out even an iota of any malified view expressed against the appellant. In other words, no malified intention on the part of respondent number 4 and 5 can be read into the UO note dated such and such as raised by the appellant. Incidentally, there is no allegation of malafide against the authority issuing the transfer order dated 28th July 2017. It is seen that while considering the allegation of malafide, the learned single judge had also looked into the relevant records and reached a finding that there was no material whatsoever in support of the allegation made by the appellant. In the absence of any contrary record produced by the appellant, we are of the view that there are no materials to disbelieve the finding of the learned single judge in this regard. The grounds of challenge to the transfer order, as stated in paragraph 9 of the writ petition, as well as in paragraph 6 of the additional affidavit filed by the appellant during the writ proceedings, we are afraid to accept the same at its face value, as there is nothing on record to demonstrate that the transfer order had in any way anything to do with the contentions advanced in the aforesaid paragraph 9 and paragraph 6 respectively. The law as it stands today, a transfer order by itself would not stand vitiated merely because the same was passed at the instance of an MP or MLA. To invalidate a transfer order on this count would squarely depend on the facts and circumstances of an individual case. In the present context, and as can be noticed from the UO note dated 14/5/2017, it cannot be held that the transfer order is bad and vitiated merely because two parliamentary secretaries were involved in the process. Now, my lord, I'll just refer to Masood, and I'll just see the language, my lord, of Justice Karju, the way he dealt with this. Because complaint was not the only thing. 2007-8 SCC, I'm sorry. 2007-8 SCC, page 150. Para 8.
Yes.
What else? 150.
Yes.
Para 8 at page 152, my lord. London Council for the Appellant submitted that the impugned transfer order of the appellant from Muzaffarnagar to Mawana, district Meerut, was made at the instance of an MLA. On the other hand, it has been stated in the counter affidavit filed on behalf of respondent 1 and 2 that the appellant has been transferred due to complaints against him. In our opinion, now this is here the court says, in our opinion, even if the allegation of the appellant is correct, that he was transferred on the recommendation of an MLA, that by itself would not vitiate the transfer order. After all, it is the duty of the representatives of the people in the legislature to express the grievances of the people. And if there is any complaint against an official, the state government is certainly within its jurisdiction to transfer such an employee. There can be no hard and fast rule that every transfer at the instance of an MP or MLA would be vitiated. It all depends on the facts and circumstances of an individual case. In the present case, we see no infirmity in the impugned transfer order. So, my lord, complaint in this case was only one of the factor, as the court said, even otherwise. Because, my lord, here the concerned MLA spoke about the people. He said the people of my constituency also desire that such a person should come. There is no application from my side. On his own, he's.
Have you denied it on affidavit that there was no application? Does your affidavit speak?
Lord,
there was no application.
Lord, in the repetition, my lord, there is no pleading.
The document is there, sir. The document is there, which refers to page 45, that it is being made on your own request. Have you denied it on your affidavit?
My lord, these documents through RTI they had obtained.
Yes, and they were part of the petition, sir.
My lord, it was necessary, my lord. It ought to have been rebutted categorically, but my lord, that document has to be seen along with two other documents.
Yes, of course.
So this is my submission, my lord.
Yes, with that,
Holistically, my lord.
you said so 3 times, sir. We'll take note of that.
So kindly, my lord, I would urge, and my lord, the affidavit of the state may also kindly be seen.
Yes,
lord,
we'll see that.
3 paragraphs.
Of course.
Anyway.
5, 9, and 12.
5, 9, and 12, page. Just hold on. Page.
Page 5, page 79.
Yes, let's see.
If I may read,
Yes.
from about para 5 maybe.
Yes.
The government has the discretion and competence to transfer an employee at any time.
Yes.
To any place in the interest of public service and for effective expenses. It is evident that earlier the government took a decision to transfer the petitioner and Assam Nebraska. This case was to be given effect 2023. But the Leperada district is a recently created impact district. It is important matter. Hence, in the meantime, the government felt that it is more experienced, official like the private.
What is the view of the department on these recommendations? What is the department's stand in the discussions? That in the public interest, it is necessary to amend the order of transfer after 6 months. Does the department say so anywhere in the discussions?
The order doesn't say.
The discussions even, sir, the discussions. Does the department given its inputs? Is silent, right?
MS Gill. Public order.
And my lord, then my lord, yes, the lobby has started DDS in different districts for many years.
That is the request of the MLA, Mr. Goswami. That is simple. Age.
They have written, man. MLA may have written, man.
Yes,
Masum's case is very clear, man. The local MLA can say something, man. That's a different thing, man.
yes.
This is our consideration, man.
Let's see. Brief.
Page 79, my lord. That's it, my lord.
Yes.
This my lord shows that my lord that order was my lord. Because the writ petitioner or the writ applicant, my lord, couldn't have taken charge, my lord. He could have filed the joining report, but.
Respondent number 6 has also filed a letter on record saying that he has taken charge on 21st.
Not 28th, not on 21st. Joining report.
So please take your seat, sir.
I'm sorry, madam.
My lord, what I'm trying to say, my lord, just. Allah submit, my lord. This was modified on 28th.
Mr. Goswami, the respondent number 6 has also filed a joining document dated 21st April. That's right. So that is 9 days before the incumbent was to retire. So you are harping on his actions. What about the respondent number 6? Without even being relieved.
I want to submit, my lord. that
Yes.
this was modified before the first order was executed.
Yes, all right. Now regarding the argument which has been, the main argument which has been advanced, Mr. Goswami.
And then, my lord, and then para 9, my lord.
Yes,
It doesn't give the date of release, but that I am getting, my lord.
yes,
The humble dependent denies the private respondent has joined as DDSC Basar Leperada on 28th of April 2023, being the last working day of month of April 23. 29th and 30th April being Saturday and Sunday. The erstwhile retired DDSC had made over the charge of DDSC Basar to the private respondent on dated so and so. That is the last working day of April.
Yes.
23.
all right.
So charge have been handed over. only on that.
Now the fundamental argument which has been raised is
My lord,
that a transfer order is presumed to be issued in public interest.
my lord.
So what is the greater public interest served in cancelling it? Does your order reflect so? Does your discussion reflect so?
The order doesn't reflect so. As your lordship.
Discussion affidavit, please. Affidavit. Read your affidavit. What is the larger public interest?
Para 12, my lord.
Yes, please.
Para 12, page 83.
Yes,
Para 12, my lord, I'll start from the last line.
yes, please.
In page 82. For administrative exigencies, the impugn order has been issued. EO note has been of course received from the honorable MLA, but EO note was not only the ground for transfer and posting of the private respondent at Basar.
Mr. Goswami, do your documents at any place indicate that this modification in the earlier transfer order was being made in a larger public interest?
For that, my lord, I have to call for the records. But in
Records
this
are
case,
there.
record, my lord, the
What more
record-
record? All discussions are there. The entire file is there in RTI. What other record do you require? All right, keep the records tomorrow. Have the records tomorrow,
Not tomorrow, but day after.
day after tomorrow.
Day
All
after.
right.
Day after.
Mr. Goswami,
Like it's-
after arguing, after the matter was heard at great length, and additional Advocate General Mr. Goswami submits that he requires the original records along with the officer in charge so as to effectively put arguments in this matter.
One aspect, my lord. My learned friend is relying upon paragraph 5 and 12 of the affidavit to show as if, my lord, there is an overwhelming public interest. My lord, public order publicly made has to be construed in the context it is made.
Yes.
Whereas, my lord, the entire note sheet has been annexed. It does not reflect.
Let him have that satisfaction of having the record.
So MS
Good.
Gill and all, my lord, Gordonji Bhanji's case will come into play.
List on
Deeply
27. 27. All right.
Not so.
And in the meantime, also take instructions. We
Well,
want this
I'm
court to
getting-
comment.
Yes, man, I'll again speak.
Yes. This is a mess you have created on the face of it. Just on the desires of the MLAs, the entire thing has been turned topsy-turvy. The other matter is coming up right now.
My lord.
So you really seriously intend to ask the court to make comments? That's your choice. Or else take a reasoned
One
decision.
document, my lord, that is in the RTI reply shows, my lord, all 6 of them have been recommended by either an MLA or.
What is this? What is this? Your earlier decision, was it without application of mind? We presume that it was done with an application of mind. So suddenly everyone wakes up. The entire order is given up.
One issue out of record, my lord, in Arunachal, my lord, there are more than over 50 tribes and communities, my lord. Now, possibly, my lord, there is an underlying idea that their own people.
Do you really want administration of justice to take its roots in
Because this is
Arunachal?
not the isolated case, my lord. There have been cases, my lord, even my friends are, they are familiar with this, my lord. But the authorities, my lord, they are not considering on that. It is not that somebody has recommended with or without any application from the party.
This is on the face of record reflecting that the entire exercise has been done simply on recommendations. So you should have taken the recommendations before going for the first transfer orders. You know, the fallout is that every transfer order which you make without there being a request, the employee concerned gets 80% of basic salary as displacement allowances. Who bears that expense? The taxpayers. Because in Arunachal, you don't pay tax. It is the other part of the country which bears those expenses. Yes, you and we included. Why this? Why this?
So let me
Why
get
this
the-
indulgence?
let me
Get
get
the record and take your instructions.
Awesome.
The other matter also, Mr. Das, let us have it day after tomorrow. Yes,
My matter can be taken up on Friday.
Friday.
Right.
All right, Friday.
This is different from.
The file of writ appeal number 219 shall be detached and listed separately. Or 219 में लिख दीजिए, list on 28th as per it. You also get your original record by the, in the meantime. Yes, Mr. Chaudhary.
Yes, my lord. I got a document, my lord.
Okay.
Interesting thing, my lord. He also transferred to Alo at the instance of minister, my lord.
All these are.
That
My
was
lord,
not.
my lord,
clear.
once again.
And another thing is director of elementary secondary education was not party in the petition. I don't know why, my lord.
My lord, these
Because
are all-
the
these are-
record is
my lord,
available
these
for
are-
direct elementary
These are
education.
besides the issue.
Yes, sir.
Here, the issue is, there was no proposal for my transfer. It is because of the interference of the minister that I was transferred.
Reserve your energy for 28, Mr. Das.
My lord, my lord.
Yes, my lord.
One of the records brought by my friend, by Mr.
My lord.
Kapoor, the root petitioner's name, his application for transfer to Mumbai and all that, and minister.
Only one thing is there, my lord, what I found. The minister, my lord, name, my lord, is reflected in the cost item. One of the council appeared before the single bench. So I think that I don't know whether minister, they will appear end of the matter. If
My
they
lord-
represent minister, end of the matter.
My lord, minister appeared
Because
before the single judge, also
division-
before the division bench.
Division bench.
Did not appear.
Single
appeared.
bench he
Represented through council, yes.
The single bench he appeared.
I have got the copy of the order.
But division bench, whether is
We don't know. The notice has been.
in Arunachal, please appear.
All right.
Now that has
All
been
right.
transferred.
So that doesn't matter. This is the
No,
principal
I'm
seat.
just- my
That
lord,
that is the,
Hardly,
Bro.
I have to tell the court.
they
in
can
Arunachal
they can always make a request for
Pradesh,
VC hearing.
No,
Even in information,
that,
even
that
the-
information.
the
that's why I'm
council
saying-
representing the
Yes.
respective parties shall be intimated that if they are unable to address the court physically, they may do so by virtual mode from Itanagar.
This is what I
Very
want.
good.
my lord.
Very
That's why
You understand?
unrepresented it should not go.
Taken, Mr.
That is my lord, what I have got with the minister. Unrepresented it should not go. That's what I am telling. you.
Okay, okay.
And this is all.
Deeply.
Item number 32.
Both matters. the same line will come. Yes, please.
The corporation has agreed to the terms and the corporation has agreed to abide by the judgment on the order dated, my lord.
Then
That no recovery shall be made retrospectively, my lord.
no retrospective recovery will be made. Then all right, file an affidavit to that effect.
My lord.
Bring this fact on record through an affidavit.
And one more thing, my lord, the appellant has.
Or if you have got an official communication, place it on record. Rather than placing it orally, file it on a affidavit, all right?
One more thing, my lord.
Yes.
The appellant have stated in their writ petition that they've closed the establishment, my lord. But no such intimation was given to the corporation. No any records have been placed in the writ petition or the appeal, my lord. In that case, my lord, the appellant is deemed to be, the institution is deemed to be in continuance, my lord, as per section 1G of the act, my lord.
You, whatever you want to say it on affidavit. And counsel, Mr. Smith submits that the corporation has taken a decision not to effect recovery
My lord, retrospectively.
retrospectively from the appellant herein.
From 2016, as per the judgment of the coordinate bench, my lord, at page 42, my lord.
In terms of the judgment of coordinate bench of this court
My lord.
in page 14 judgment
Page, my lord, 28, my lord.
in the case of all Assam Medium Schools Association and another versus State of Assam and others being WPC 4121/2009 decided on and analogous writ petitions decided on 28 January 2016. He submit that he shall be bringing on record this stand of the corporation through an affidavit within
3 weeks, my lord.
3 weeks. List of 3 weeks, interim order shall continue. There's an interim order.
Yes, Lord Chief. Yes.
Item number 34 and 35.
Lordship, we have filed reply, Lordship, that is probably not on record, Lordship.
You have filed affidavit in reply.
Lordship.
It is stated that affidavit in reply has been filed on behalf of the petitioner. The registry to check and tag the same with the record. List after 3 weeks. And re-notify the matters after 3 weeks. But that 36. This has been adjourned. Yeah, okay. Daily supplementary.
Supplementary matter, item 54. Item 54.
Matter, Lordship, had taken up yesterday, my lord, the headmaster in a high school and the high secondary school. He was here, I saw him outside.
He'll come, pass over. Yes, is he here? The council? No. Okay.
Daily list, item 37 for final disposal.
Which item is talking about?
Lordship, I prayed for some accommodation. Lordship.
In which
I could not
case?
prepare- I could not prepare the.
Which
papers.
one? 54?
37.
37. All right. 37. And council. Mr. Chakravarti. Mr. Chakravarti, praise for time as he is not prepared with the matter. These are your writ petitions. This is disciplinary matter.
Lordship, the charge memo was passed by on the ground of delay, Lordship.
Delay.
12 years delay.
Yes. When will you argue the same?
Next week, any date, Lord.
List of 4 weeks.
My lord, short date, my lord.
Why?
A promotion is held up because of this.
Promotion is list on 17th August.
All right.
For hearing, item 38.
I may just point out before this court.
Yes, Mr. Das.
I may just point out before the court,
Yes.
for implementation of the impugned judgment, they have filed a writ petition before the court during the pendency of the writ appeal. We have filed a review petition there. Matter is fixed on next week.
So you want us to wait?
The judicial.
You want us to wait for the outcome?
8 August.
My lord, the review is on the ground that, my lord, we have not mentioned about filing of this appeal. But fact of the matter is, my lord, during the course of the hearing, this aspect was brought out to the notice of the honorable court. Because we inadvertently, it was not indicated in the petition. The review is sought only on that ground. My lord, what will happen in this case, my lord? Our appointments are being held up for quite some time now, my lord. Now, what had happened, the case of my learned friend's client is that somebody approached her. She got the news sometimes in my lord August, but she filed the writ petition after 4 months.
Approached her for?
That's for some favor. If you want a job, yes.
Okay.
Somebody.
Interview manipulation, my lord.
Whether it is
manipulation, my lord. On the face of the record, if your lordship sees
this is a matter of this is a writ appeal of 2019. I think better my learned friend argue the matter, my lord.
No problem.
Yes,
my lord.
please
I'm just
argue.
pointing out judicial propriety, my lord, because during
That
the
is for execution of the order, seeking
court
execution.
directed that you must implement the order within a period of 4 months.
All right. So
Without
if that
hearing-
order is, if this
Yes,
order is
yes.
interfered in the appeal, there is no question of implementation. So the order in appeal will govern the that writ petition.
Yes, I'm just pointing out, it's my duty to point it out. my lord.
Okay.
Hello, the advertisement was issued on 15/12/2012 for filling of the post of 14 district malaria officer.
Yes.
That your lordship will kindly see page 51. And what is relevant is, this is the advertisement. On last occasion, your lordship wanted to know what is the rule. We found out, my lord, 1995 rule is there, where, my lord, these posts are not mentioned, but there is a provision that it will be selected by the commission.
By the commission.
Now, 2017 is there, it will be selected by the board, not by the.
Now the commission is otherwise in disarray. So many issues pertaining to the APSC.
Yes.
Yes.
Now, 51 by FLR mentioned post, your lordship will kindly see page 53.
Yes.
This, if the number of applications received are large, the commission may shortlist the number of candidates either on the basis of their marks obtained in the qualifying academic examination required for the post, or by holding written examination, which will be notified in due course. Only 56 persons were participated in the process.
56.
56%.
There are 15 posts. 15
posts.
14 posts and 56 participants.
56.
Okay.
Now the written test, my lord, the petitioner has passed. Then thereafter, my lord, viva voice text was fixed. And before the viva voice text, your lordship will kindly see page 57.
Yes, please.
57. This is the declare the results of the screening test for the post of district malaria officer. Petitioner is selected here along with others.
Petitioner, appellant.
Appellant, my lord.
For the viva voce.
Yes.
Yes, short, yes, all right. Then
Shortlisted in the written. Then, my lord, problem arose because she received a phone call from one Mofidul Islam. Mofidul Islam is a forest ranger. He has been charge sheeted in another case. So my point is, my lord, the Mofidul Islam who has called her, that saying that if you want to put.
how is he connected with the selection process?
He is not connected. He is the person probably collector, my lord.
A call received from a random person
This
How does
person-
it affect the selection
I'm
process?
pointing out, my lord, other things are also there.
Yes,
I'm
please.
pointing out this Mofidul Islam, my lord, he gave a call and it is a police case has been filed and they found, my lord, probably what this call is for. And the call, he said, my lord, if your name is to be shown as passed, my lord, you will have to fulfill the demand.
Yes.
This is what it is. Now, the interview was taken by Basant Dale, member of the APSC. He has been also charge sheeted.
Yes.
Both in other case, in other APSC case, both this Mofidul Islam and my lord Basant Dole, who took the interview, my lord, they have been charge sheeted in another APSC case. That I have enclosed in the additional.
When did you, for the first time, make a complaint about the so-called call?
Yes. My lord, no, we made this, there was in the 16, my lord, the call was made and we filed a FIR on 7/11/16.
16/8/16.
16/8/16.
Let us see your representation dated. Just hold on.
Date was 18/9.
Mr. Das, before that you submitted a representation.
Yes.
Let us see that representation, please.
Representation. Representation was filed at page 72 on 16.
Let's just see that representation.
Page 72.
Page 72. Yes, so this representation even is issued, is filed in November, right?
Yes, November.
After lodging of the FIR.
Yes.
What is the fate of the FIR?
FIR fate, my lord, the investigation was going on. I do not know. as of-
7/11.
Yeah, we have seen that.
Allegedly, the telephone call is dated 16/8, results declared on 17/8, FIR on 7/11/16.
That I'm showing out.
That aspect has been taken note of.
Mr. Das, we want to know what is the fate of your FIR, sir.
FIR, my lord, that the government will be able to say so.
Yes.
I'll have two aspects of the matter. Let it come to some conclusion, my lord. FIR has been filed.
Yes.
My lord, if your lordship sees the record will show 50% marks on the basis of the educational qualification. There is no problem. 20% marks on the basis of the subject knowledge. That is a technical man. There also we have no problem. 30% general bearing, your lordship will see what is the general bearing marks, all erasing, overlapping. If your lordship is satisfied, I have no.
For that purpose, have you filed any FIR against the members of the board?
Yes.
That they have fabricated the record?
My lord, members of the board, if your lordship see the record, my lord.
But how do you say so? From where do you say so?
Record was produced before the court. We have seen the record.
Let's see the single bench of the observations.
My lord,
After seeing the
I have
record.
stated in the additional affidavit that
Mr. Das.
what kind of erasing marks were erased.
Was this argument raised before the learned single judge?
Not a
Let's see.
single judge we produced, we argued mainly, my lord, on the ground that the written marks were totally overlooked and only on the basis of the interview, the marks were taken.
Which is incorrect, which is incorrect.
Yeah.
Your distribution in the result sheet, let us see that.
That has been brought here, my lord, on record. We are allowed to see it here.
Where is the assessment sheet, sir?
My lord.
You are supposed to bring it on record.
My lord, I brought the record, my lord. Your lordship will, can you say additional affidavit? What is it?
Yeah. That was shortlisting. Final assessment.
Para 3 we have stated in additional affidavit.
Those are 70, 20 and 30. That's what.
Please, yeah. Is who prepared, I do not know.
Para 3.
Just hold.
In the additional affidavit state. Last, last occasion when the matter was brought before Honorable Justice, my lord, the record was produced. Your lordship has seen the record.
Just a moment. Judgment. Saying. Main APS, not this one. Yeah, right. That I know that. Yeah, this, some erasers. There are overwriting. What is the fate of your FIR, sir? We would like to know. Has anyone got the information? Mr. Mazumdar,
My lord, charge sheet has not been filed, sir. Okay?
then what happened? That was registered in 16.
Yes.
The case could not be pending, cannot be pending now after almost 7 years. Let us know the fate of that case.
And learned single judge has also made an observation, my lord, depending
Yes.
upon the outcome in the criminal case. In future, if something
find out.
emerges,
We'll find out.
yes,
Mr. Mazumdar, let us know. Mr. Mazumdar, Additional Advocate General, Mr. Mazumdar shall apprise the court regarding fate of the ACBPS case number 18/2016, registered at the behest of the petitioner on the next date of listing, re-notify on 8th August.
Item number 39.
In this case,
Yes.
I would like to file an affidavit annexing the report of the magisterial inquiry, which was submitted in 2019.
Okay.
Along with some other reports of the high-powered committee, which was concluded last year. Even the high-powered committee, where one of the senior police officer was also in the team member lordship,
Okay.
they have also indicated that it should be inquired by a specialized agency. So I would like to
Seems
bring
so.
everything before this honorable court. Because we also want
apparently, the postmortem report was there with us.
Postmortem report is very clear that it is a case of hanging. It is not a case of. I'll place the affidavit.
Let us see let us see the effect.
The
Where
doctor's
is the
report is
postmortem?
very clear. The police investigation report is also, the doctor deposed. It is not a case of strangulation.
No.
It is a case of hanging.
Just pass it on. Modi medical jurisprudence now. Medical jurisprudence.
So that is why we also want to find out from where
Ms. Saikia, let us have the postmortem.
postmortem report.
We'll tell you why the conclusion is wrong. You shown that picture, no? Where is that picture?
Any record?
No, no, it's not that case. उससे hang किया हुआ.
Report.
Same case. Ms. Saikia,
Yes,
we'll just give you one small indication.
lordship.
Only one line in the postmortem, 4 words in the postmortem report.
Lordship.
They are sufficient to conclude that it is not a case of suicidal hanging. It's clearly case of strangulation. We have just flagged it. What you are saying that it requires investigation
Yes.
by a higher agency, even your doctor has been influenced. We are telling you in so many words.
Lord.
So one simple sign in the postmortem report that is sufficient to conclude so. You just have a look at it. Because this is death by asphyxia, which has many manifestations, right? So the stark difference is in a, we have the flag we have put, just
Yes,
look,
Lord.
what does it say?
Left neck vessels found
Bruised. In case of suicidal hanging, what happens is because of the body weight,
Yes.
instantly the blood supply is stopped. So the underlying tissue, when it is dissected, it will be parchment-like. That is the basic difference. In a case of strangulation, it takes time. So the blood keeps on flowing. The bruising occurs in that. So that is the simple or a single reason to discard the conclusion that it is a case of hanging.
Here, there is one indication from the inquiry, Lordship, that he tried it twice. The first attempt he failed, then he made a second attempt.
In hanging, the control of the person who does it, it is gone. So moment that is gone, there is no possibility of the blood keeping on flowing. So once that comes in, there's no question of
That is why
bruising.
even we want,
Bruising, yes, that's
even
what.
we want that it should be investigated by a specialized team. There is no doubt on that. But from where that rope,
Yes.
the jute rope entered the lockup, that also we want to find out. Because this particular man was of great importance to the police or the forest department. Because next day morning, he was supposed to find out all the places where the booty was kept, the properties he has seized. That was not very important. The most important and critical part was that he was to give the lead to the persons who are involved from Nagaland. He was supposed to go there also. So he has stalled the whole investigation.
100% case of strangulation, 100%.
If it is strangulation,
doubt.
our officers will face the consequences.
No doubt about it. Mr. Saikya, you just see what
That is why, Lordship,
that you can take from my experience, Mr. Saikya.
I definitely.
I've got ample
Lordship,
experience on this regarding medical
ultimately,
jurisprudence.
Our investigation may then, Lordship, may
But then which specialized agency? Let us know.
let me first file the affidavit, Lordship.
Day after tomorrow,
Kindly give till Monday.
Monday. All right, Mr. Saikya submits that he proposes to file a detailed affidavit of the senior police officer. He further states that after thorough consideration of the metal available on record, the department is also desirous of getting the inquiry conducted from a specialized agency.
No, that is not the department, the high-powered committee.
The high-powered committee is also desirous of getting the investigation into this matter conducted through a specialized agency. List on 30th.
May I take a photocopy of this, Lordship?
What? This is Modi
only
medical
this page.
jurisprudence. Modi's medical jurisprudence.
I think I
You'll
have
be having
it.
your book in your own office.
Yes, Lord.
You can take a photo. Click a picture from mobile. Just pass it on. I will show you that chart where the differences are there. There is a chart in this very section where the author gives out the difference between
Lordship.
strangulation.
One more thing, Lordship. The
Yes.
investigation is almost completed. As because the case diary was in the court, Lordship, we could not finally close the investigation. If Lordship permits that also, we can do it within 7 days' time.
But closing the investigation, what would be the purpose? That will be burying the things.
No,
Your officers are not saying that it is a case of murder. They are saying that it is a case of suicide, which is absolutely incorrect, Mr. Saikya. You take your opinion and we'll say so.
Lord,
Then we'll
let
assign the
us file the
investigation
affidavit.
to an agency outside the state. Then we'll do that.
No difficulty, Lordship. Recently,
Yes.
we have given that Nagaon case to also CBI.
But this is a case of that nature. You see, you take a copy of this page. Or you get
It's
a copy.
okay, Lordship. I have the book.
No, this one. There is all differences are charted out. What is the difference between
Photocopy.
the two sorts of
Mobile.
asphyxia? Okay, list on 30th.
Deeply obliged. Their further appearance, whether it
The personal appearance of SP so and so is dispensed with.
highly
But
appropriate.
this cover-up operation, we don't really appreciate this open and shut case of murder. Why this? Why this attempt to save the people
No,
who are responsible?
It may not be that way also, Lordship, because it has really troubled us. the
Then why,
forest
why
officials.
proper, why didn't you, the state is empowered to get the inquiry conducted from a different office.
No, we had, that is why Lordship, that high powered committee which consisted of senior forest officer, senior police officer, and another person from the executive Lordship, commissioner.
We asked Learned Senior Counsel, Ms. Saikia, to sit down with the postmortem report and Modi's medical jurisprudence and take a
And
decision.
the doctor, but same doctor has given the opinion before the police officer. He has given the statement. It cannot be a case of strangulation. So his writing and his statement before to the authorities are totally conflicting in that case. So we have to find out whether the report, whether we should.
What is the opinion given, final opinion in the postmortem? You had a photocopy yesterday.
He has given a very clear, that's hanging. The last line, the final opinion is hanging.
Apparently a wrong opinion, apparently. That is contradicted by the
The
findings
last
of
page,
the,
Lordship will kindly see.
yes.
And he has given a very specific and categorical statement before the police and also before the judicial magistrate.
Tongue bite. Subdural hemorrhage found bilateral. All signs of,
Due to X-ray as a result of injuries sustained, that is hanging.
apparently, in hanging, there are no injuries. There's no question of injuries being sustained in
And
hanging.
his justification is that had it been a strangulation, there will be ligature mark throughout the circle.
That's wrong. Ligature mark is there in a case of hanging because the entire rope.
Only one angle, if it is a hanging case, it should be only on one angle, one side. Discontinuation. This is his justification.
Swollen right ankle joint. So he even fell during the attempt.
That was before the previous day, and before that he was given treatment also.
Maybe
he was sent to the doctor for treating his
Anyhow,
ankle.
you come out with your affidavit,
Yes,
then
Lord.
we'll have a discussion on that. In the meantime, you try to study the postmortem report and Modi's medical jurisprudence.
Lordship.
You will yourself realize that this report is a
No,
farce.
Lordship, we want to be
It is a
fair.
cover-up operation, apparently. At the local level, the doctors are not free from the influence of the local SHO.
That is one way of looking at. But
commonly
at the
seen.
same time, the forest department wanted the service of this man who was behind the bar because he was supposed to take our official.
Your informer. He was your informer.
No, he was not the informer.
Then
at 8 o'clock on that night, the day he died, Lordship, 8 o'clock, one informer came and met him. Only thing is that from where that jute rope entered into the custodial area.
Yes.
That is the core thing.
Yes.
Who supplied that rope? We want to find out
Not
that
a case
particular
of
person.
supplying, Mr. Saika. It is a case of hanging him after murdering. It's a case, clear-cut case. There's no doubt.
There may be two expert opinions, Lordship. We are in the middle.
Well, you choose which expert you would like to select.
We will place everything before this honorable court. And this honorable court will have
Now,
to take the.
now we will request you to have a look at the postmortem report and then give us.
I'll look it from the academic side, Lord.
Yes, that's the only
my
thing.
academic exercise I will do.
All right.
But ultimately, the final call, this honorable court will have
Very
to
well.
take.
On 30th, we'll see.
Highly obliged.
31st. All right, 31st.
Item number 40.
Lordship, in this case, I
Yes.
have received the instructions last night.
Yes.
Why this judicial magistrate is not involved. I'd like to place an affidavit. What was the reason? Whether there is a direction from the Human Rights Authority on the interpretation of section 176.
176.
Yes, Lordship. So I'll place that on record, Lordship. Kindly give me 1 day's time.
Saikya submits that he has received fresh instructions on the query posed by the court on the last date of hearing. He prays for and is granted short opportunity to
27,
posed by the court on 20th July 23. He prays for short opportunity,
Lordship,
to bring the relevant facts on record through an affidavit list on 4th August.
there was a specific directions from the Human Rights Authority, Lordship, that it should be done by the executive magistrate. In 2008, they realized it and then corrected it.
All right.
That for 10 years period from 2010 to 2020, that was the position.
Oh, Okay,
I'll place that law.
sorry.
Highly
What
obvious.
about the compensation part we have observed?
Compensation part, Lordship, if finally Lordship finds that
Okay.
there is some default on our part, Lordship may impose it.
Because there are
But
some cases
it
wherein
may-
there are cases of injuries being received in the custody.
Yes.
If
There
we
are a
find-
few cases.
Because there is no reason to have anything against them, Lordship. These are-
Obviously, they were simple under trials or convicts.
Lord.
So if they die in custody
If
and they,
because of our default, if anybody has suffered, then definitely Lordship will take a call on
you
that.
just take a instruction on that.
Yes, Lord.
Very good.
Lordships, may I just point out one small thing? In the
Yes.
last order, there's a recording by your lordships that one Arjun Saharia is the one in which the magistrate inquiry was conducted. That is incorrect, your lordship. What
Alright.
is Mr. Babul Biswas?
There is a land council MS Chaudhary has pointed out that there is an error in recording the name of the person Arjun Saharia in the order dated 20th July 2023, and that the case wherein judicial magistrate conducted the inquiry was of
Babul Biswas.
Babul Biswas.
Lordship.
The necessary rectification shall be read in the said order.
Lordship. Deeply.
Lordship next date.
4th August.
Highly obliged.
Item number 42 to 47.
In this case, Lordship, regarding the decision of the state government, Lordship, we have filed the affidavit, which is before this honorable court today on record.
Yes. Today you have filed it.
No, we filed it last
Filed.
Monday.
All right. That
That decision, why,
scaling,
yes, to grant grace.
grace
mark.
mark, scaling, whatever.
Yes. The other
Yes.
side may like to respond to that also. Lord.
We have brought an affidavit, my lord.
You also brought an affidavit.
No,
They have given an
we have
affidavit.
filed an affidavit. Here only, I do not find any decision here. Simply, the statement reiterated, which was made before the London Chigal job, with of course certain addition here.
So that decision is not on record.
No, nothing has been placed on.
Copy of the decision.
That has not been placed on it.
is
I
like a-
placed the decision before this honorable court, the whole file was placed.
All
Then
right.
this honorable court was pleased to direct that, bring it.
On
then
affidavit.
I cannot place the whole file on affidavit.
Not the whole
So the
file.
contents we have given.
Not the whole file. At least the final decision whereby you.
Yes, we have given it in
Where
the
is that?
affidavit.
Where is that?
Exactly, that should come if there is any in the form of any decision.
If there is a formal decision,
Yes.
that of course will.
That should have come.
Where is the affidavit?
Affidavit पण द्या ना, मग आपण बोलू, राजेश.
It was
Is there a
filed,
separate file of affidavits?
it was filed on 21st of April. No, sorry.
July.
July, 21st of July,
186.
186, readable 186.
राजेश को, राजेश.
Who appears in 186? The 186 is by the state.
This number,
Page
186,
186.
no, page 738.
738.
Page 738.
738.
All right, let's see. इसी में होगा. ये फाइल कौन सा है? 186 का है. इसी के अंदर होगा. जजमेंट है. These are paper books. These are all judgments. ये दो सेट तो जजमेंट का ही है. Files are ending at 400 and something.
I'll go ahead, ne?
42, no? Could you get it loose? This must be it. And this is the affidavit, 25/7. Shahnawaz Chaudhary.
Yes, yes.
Yes.
Chaudhary. Paragraph 2 lot.
Paragraph 2 law.
So there are two decisions. Proposal is 27th February and the
Yes.
decision is of 2nd March.
Yes. And result was declared on 4th March.
Ms. Manta,
Hello.
so they have referred to whatever decisions they have taken. They have
Well,
referred in the, in
That
this.
is what my concern is, they have simply referred to that there was a decision. They
That
you said
record was
earlier also
there.
that there was a conscious decision on the part of the authorities to take.
The entire record was produced, sir. That is, they say on affidavit that we have taken a conscious
No,
decision.
My contention is if there is a formal decision taken to that extent,
All right, Ms. Saikia, bring the formal decision on record.
that should be
The,
placed. Otherwise,
the two things, the proposal dated 27th February, Ms. Saikia has filed, the authorities have filed.
It is in the note sheet, Lordship. I can annex those note sheets here.
That note sheet will serve the purpose.
Yes.
Ms. Saikia has
Because
filed.
Lordship was pleased to peruse the note sheets.
We have seen that, of course. The affidavit has been filed on behalf of the Secretary, Government of Assam Department of School Education in terms of the earlier directions regarding the decision taken by the state government for grant of grace marks to the candidates for facilitating the declaration of the results. The affidavit recites that the recommendation was made through the chairman of the TET Empowered Committee on 27th February 2020 to grant grace marks to in various papers. The said proposal was accorded approval by the Honorable Minister by the order dated 2nd March 2020, and the results were declared on 4th March. Ms. Saikia shall bring the relevant note sheets on record, Lordship, so that the matter can be examined in extenso. List on 8th August.
Deeply obliged.
Ninth,
I have difficulties, my lord.
then it goes to 10th. It has to be on a hearing day.
Well, I-
10th August.
No, my lord, I'm sorry. For me, 9th, 10th, 11th, I will be out.
Let it be after Independence Day.
Then it will be after independence, 17th August. Copies of the affidavit and the note sheets be provided to all learned counsel appearing for the parties.
My lord, may I also indicate that even I have not been served with the appeal memo at a copy department. Appeal memo has not been given.
There are appeals from all sides, Lordship.
At least in this
As
state
Lordship has just right, say,
I'm interested.
more than 800 pages. We'll do it.
No, the note sheets, you just provide the basic decision and the recovery.
No, regarding the whole memo of appeal.
Memo.
We'll do it. Lord.
I don't know.
PK copy lage dikhiba.
Obliged.
Highly obliged, Lordship.
Item number 48.
May it please your lordship.
Yes.
In item number 48, my lord, today at 11:40, I have received additional affidavit, my lord. I would like to respond to this. I have to send to my client.
What is the matter about?
Matter relating to my lord, on the last occasion when the matter was taken up, my lord, your lordship wanted to see the judgment rendered by your lordship in Rajasthan High Court.
On what issue?
Issue relating to my lord, whether my lord, criminal proceeding and departmental proceeding
Can
go
travel together.
simultaneously
Go
if it is
simultaneously.
based on same set of
Same
facts,
set
my
of
lord.
facts.
In this matter, my learned senior counsel, Dr. Saraf is appearing, your lordship. Since
All
I am
right.
taking time.
Affidavit, and senior, and Advocate General Ms. Saikia has filed an affidavit on behalf of the respondents today.
Today, my lord.
The same be brought on record. The appellants may file a response thereto if so desired by the next date.
A short date may be given.
We'll
There
give
is
a
some urgency on our part, Lordship.
We understand.
After 15th, my lord.
No,
After
it will be too
15th.
late, Lordship.
Then
We filed it today.
No, this is in response to the honorable courts on a specific direction, Lordship, on a very particular point. It is not a general affidavit, Lordship.
Also, we just observed that you may complete your instructions regarding the government's weight in the additional affidavit. There was no direction to file an affidavit.
But we thought it that it was.
Then
Because there was an indication that we have violated the honorable court's order, that there is a stay order, thereafter also we
all
proceeded.
right.
To clarify that.
Now we understand. Now we recollect. List on, then we'll have it on 7th August, Mr. Lordship.
7th August.
7th August.
Highly obliged, Lord.
Deeply.
Item number 49.
Yes.
May I please, Your Lordship, Lordship, this appeal is directed against an order of the learned single judge. Your Lordship will find that at page 174
Hmm.
of the memo of appeal,
Yes.
whereby Your Lordship, the learned single judge has held that the provisions of the Payment of Gratuity Act
Hmm.
would apply to the
AFC.
Assam Financial Corporation, and accordingly, Lordship, direction was passed. And may I take your Lordship to paragraph 23 onwards. Twenty-four, Lordship, 24 onwards.
Yes.
A comprehensive.
Come to para
review-
19.
Lordship.
Para 19. That
Yes.
should be the
Yes,
thing which you will require to surmount.
yes, yes,
Come.
Lordship, yes.
Para 19.
Now,
Para 18 and 19.
yes. In view of the above, the conclusion we arrived at is that.
Para 18.
Yes, I'm reading that.
Hmm.
In view of the above, the conclusion we can arrive
Yes.
at is that the present petitioners in the context of their employment would be covered by the provisions of the Act 1972.
Hmm.
The next question for determination would be whether the gratuity payable to the petitioners would be circumscribed by the provisions of the two regulations, namely Regulation of 1964 and Regulation of 2007 of the AFC. In order to arrive at an answer to the said question, we need not go beyond the provisions of Section 14 of the Act, which is Lordship, an act to override other enactments.
Yes.
Now, this
So
is
overriding effect is given.
overriding effect. The
Yes.
provisions of this act or any rule made thereunder shall have effect notwithstanding anything inconsistent therewith
Hmm.
contained in any other enactment other than this act or in any instrument or contract having this. So Lordship, in this connection, Lordship, I would beg to refer to
Beyond the payment of the Payment of Gratuity Act and the regulations, both. Let's see. Yes, what are you referring to?
I will be referring to only two decisions, one of this honorable court
Hmm.
and one of the Supreme Court of India,
Yes. Let's see.
which I find Lordship subject in my favor, Lordship.
Let's see. Let's see. Hmm.
Essentially, the right of entry to receive better terms of examination.
Better
Or agreement or contract.
So the extension is given to the employee. Yes.
If I may take your Lordship to a decision of our High Court.
This judgment you are citing, superintendent of post offices, how that will be applicable?
Here, Lordship, if I may take your Lordship to
The part-time employees. Gramin does it is a different kind of service, it's not a substantive service as such.
If I may take a lordship to page 7 of that Supreme Court judgment.
Yes, please. Page 7.
Page 7 of the judgment, lordship. It says 2A of the 72 Act, however, specifically excludes persons who are governed by any act or rules providing for payment of gratuity. In fact, we have got our own rules.
But the effect of the non-obstante clause.
Lordship, that is there.
Then
That I cannot dispute, Lordship. Here is a case where the Supreme Court itself says, if it is governed by any other act.
the non-obstante clause was not considered in this judgment.
Lordship, and so also in the case of our High Court, Lordship.
Yes, let's see that.
I would just refer to 2-3 paragraphs, Lordship. If your Lordship will see paragraph 4 of the judgment. Mr. Datta, Senior Counsel.
Mr. Chaudhary.
Yes.
If you are referring to the Supreme Court judgment,
Yes.
the Supreme Court rules, Gramin Das Sevak is not an employee under the 1972 Act. There is no dispute on your side. They are not employees. The Supreme Court says the Gramin Das Sevaks are engaged as extra departmental agents, a post governed by 2011 rules. These rules have a separate provision for payment of gratuity to extra departmental agents. So that's a different category entirely who are being governed by a different set of rules. Herein, it's not your case that they are not regularly paid employees. It's not your case. So this judgment would not be of any assistance to your case. What is this court judgment? Let's see.
Okay.
Yes.
I'll just refer to a few paragraphs, if I may take a lordship to paragraph 4 of that
This judgment, this division bench judgment.
division. bench.
Yes, please.
So learned senior counsel appearing for the original respondents further relied on the judgment of the division bench of this court in so whereby the division bench of this court, while examining similar regulations of United Bank of India, has held that the regulations being specially framed would govern the conditions of service of the employees of the bank and would override the provisions of the Payment of Gratuity Act 1972. So and so contended that as the service conditions of the present respondent are governed by the provisions of the 2010 regulations, the respondent being eligible for payment of gratuity has to have the eligibility criteria prescribed on the regulation. 72. According to Mr. So and so, senior counsel for the apparent bank, here, in fact, the court has held lordship and there is another special regulation applicable to the organization that will prevail over the payment of
Because
gratuity.
the reason was that the statutory regulation which was applicable in this case provided a higher rate of gratuity. That was the reason.
Yeah.
That is what section. So if it is to the advantage of the employee. Section 4. Section 4, 5, come to section 5.
Section 4,
4 subclause 5. So if the agreement or the regulation gives a better rate of gratuity, then that can be adopted. But if it is to the detriment of the employee, you have to fall back onto the Payment of Gratuity Act.
That is there, but what I find lordship, since this is a different enactment, and the learned single judge has gone to the extent of holding that this is a company under the company's. This is not so lordship. It was nobody's case before the learned single.
What difference would that make? There is an establishment covered by the Payment of Gratuity Act. Can you dispute that? Do you dispute that?
Lordship, since there is a separate regulation for gratuity under the
Where is your
financial
regulation?
calculations.
Let's see your regulation.
Regulation lordship is there.
Let's see.
Lordship will come to page 104.
Amendment. Amendment 102,
Right.
102, 107. Amendment. Amendment 107.
So the act comes into force subsequently. The Payment of Gratuity Act has been
Yes.
promulgated in 1972.
Yes, Lordship. That is-
It has a non-absentee clause overriding effect. So your earlier prevailing regulations,
Lordship.
how would they hold the field in light of this act?
Lordship, in view of the non-obstant clause, that is the budget. Here is a regulation framed under the financial corporations.
Amendment.
And
The regulation has been amendment 2007, your lordship.
that is
They've been amended.
Amended, because on page 107. of the read- 107.
Yes, what does it say?
An employee to be eligible for payment of gratuity must complete service of the corporation for minimum period of 4 years. That comes gratuity. is
Are
to be
you
paid.
claiming benefit of this regulation
Yes, yes.
or under the act?
Under the act, they have said that they will follow government notification as well as payment of gratuity act. And in paragraph page 71, they have admitted that I am entitled gratuity as per section 4, subsection 3.
no, Lordship, it is not correct.
Your lordship kindly see India affidavit
Page 72.
71, paragraph 7.
Just, yes.
I will read out the sentence, paragraph 7, Lordship.
They say that they are not entitled,
Is not applicable.
not applicable.
Last line, your lordship, last 3 lines.
Read.
Last line, service regulation governing the payment of gratuity act as mentioned under section 2E and section 4, subsection 3 of the payment of gratuity
It
act
starts
72.
It starts with not applicable, Lordship.
Not applicable. Payment of Gratuity Act is not applicable
And
to
even
the petitioners.
they have also took a resolution to place the matter before the board of directors,
Where is that?
Yes.
and that has been placed in my affidavit.
Page.
That is page 118 of my affidavit. After the single bench judgment, they have placed the matter before the board.
Yes.
If I am reading the memorandum to the board, 22/2/3/2022.
You're reading at page number
118 of my affidavit.
118.
Eight.
118
And that
is
is
a
serial number 290.
290.
90.
Huh? That is reading.
There is no dispute about the matter being placed before the board.
And board
Thereafter,
says,
the
board deferred it due to pendency of the appeal, my lord.
board had
They board
decided to file an appeal, Lordship, and that is how we are before your Lordship. It is not in dispute that it has been placed.
Yes.
It's not
All right.
disputed, Lordship.
Yes. Then,
Now, Lordship,
yes.
Lordship was,
No, it's okay. Carry on.
Lordship, my only submission would be, Lordship, since these regulations have been framed under the State Financial Corporation Act. And it's a
Yes.
separate enactment altogether, making a provision for the payment of gratuity, Lordship. My submission would be, it would be covered under those regulations.
What about the effect of the non-obstante clause in the act? After coming into the force of the act, what would be the situation?
Lordship, that is.
Your provisions in your regulations, which are contrary to, or which
Would be deemed to have
which
been-
act to the detriment of the employees,
Would
they
be-
will stand impliedly overruled overruled by this act.
I do
Then
agree with you.
how do they deprive, how do you deprive the benefit to be given to the employees by
Here-
the regulations?
Here, Lordship, since this, the payment of gratuity act would be, in my humble submission, would be applicable to those institutions or those organizations, Lordship, where there may not be any regulation.
No,
or not
no, read
regulated
14
under-
again, read 14. The provisions of this act or any rule made thereunder will have effect notwithstanding anything inconsistent therewith contained in any enactment other than this act. So your enactment regulation is other than this act.
Lordship.
It is covered by that.
Considering that there is no
Yes, what do you say?
So I have given some judgment, your lordship, in my affidavit, there is white is sanctioning law.
Which judgment you are referring to, sir?
2013, page 2013 SCC 472.
What is the page?
That is 2013, your lordship, page 57 of my affidavit in opposition.
Yes, YK Singla.
Yes. Paragraph 16, 20, 27, 20, 22, 23, 24. This judgment, your lordship, paragraph 23 and paragraph 16 I am reading first.
Yes.
Subsection 5, subsection 4 of the section 4 of the Gratuity Act permits an employee to be regulated for the purpose of the gratuity under the alternative provision, arrangement, award, agreement, contract, other than the Gratuity Act. In such eventuality, subsection 5 aforesaid as you assure that employee concerned to receive better terms of gratuity under any award or agreement or contract of the employee. Since the applicant claimed the gratuity regulated by 1995 regulation, it is evident that his claim of gratuity is liable to be determined by ensuring his right to better terms.
Ms. Chaudhary, you are having this judgment.
No,
Why he has given you a copy?
No, yes, sir, I've given
in the
copy.
affidavit.
I've given advance.
It is in the affidavit. Read para 22 of this judgment. You'll get the complete answer. Page 72.
Paragraph 16.
YS Singla.
And here they have limiting it the amount by regulation.
Yes.
Read para 22. And para 24. The benefit of interest inuring to an employee as has been contemplated under section 3A of the Gratuity Act cannot be denied to an employee whose gratuity is regulated by some provision, public instrument other than the Gratuity Act. This is so because the terms of payment of gratuity under the alternative instrument have to ensure better terms than the ones provided under the Gratuity Act. That was what clause 4.5 was. Section 4.5. Okay, very well. All right. Dismissed. All right. Dismissed. Done. There, more matter, two, that's, yeah.